Shoes. Recorded live.
Welcome, everyone, to this Wednesday, August 17th, 2011 edition of the Free American Show, this scheduled Wednesday. Welcome to NTT as New Trust Technology. Welcome to Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Been going over the maxims in equity. Left off on 2 to go out of the Phelps book. We're starting out of the Phelps book again on page 384 in the PDF, or at section 256, which is page 344 in the book. And that's in the Phelps book. Section 256, that's 384 in the PDF, or 344 in the book. Take notice and acknowledgement with agreement with this show and or documents is private, not to be construed or relied upon as being legal advice for any individual legal situation or employed for making legal decisions, and you will not use any of this information for making a legal decision or performing a legal procedure which is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved, without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of therein reference, and has no interest in any issue referenced to it therein, and is not a party to this or any action arising from, and is only acting as an authorized capacity as liaisons to communications between the parties. By reading or using this information, you acquire knowledge and agree that you are not a client of Christian Walters. These documents and show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. Now back to Phelps. Phelps breaks down the maxims in 2 categories or classes. One's the enabling maxims, which consist of 8, the first 8 in the group, and he breaks all these maxims down into subgroups. So the second main group is the restrictive ones, and that's what we're working on right now, is the restrictive maxims. We're on the restricted maxims right now. We're on the last 2 of that section in the book. Keep in mind that the subgrouping of each of those maxim groups is multiple ones, because this 5th one that we're doing now, must come with clean hands, works as a group, and in that subgroup is number 4 and number 6, which is who seeks must do equity, and equity aids the vigilant, and those 2 work with this one we're talking about tonight in 5, must come with clean hands. So they need to be taken in groups in their understanding. So page 384 in the PDF, page 344 in the book, section 256. He who comes into equity must come with clean hands. He that hath committed iniquity shall not have equity. It's upon this principle that a fraudulent grantor is not permitted to gainsay his own deed, nor a fraudulent grantee to obtain reimbursement for money paid as part of a fraudulent transaction, nor a party to be relieved from a judgment on the ground that the obligation on which it was rendered was in fraud of the law. Specific performance will not be decreed when it is apparent that the object of the contract was to defraud creditors. No relief will be granted in equity to purchasers of claims against an insolvent corporation for the purpose of speculating upon the liability of stockholders. A party cannot have relief directly inconsistent with his sworn testimony as a witness in a previous stage of the same case, or even in a previous case. A party has been obliged to make good a loss incurred through his own negligence, cannot, by subrogation, recover another whose negligence contributed. A party depositing money with a bank to give fictitious credit to a corporation is not allowed to withdraw it after the purpose of the fraud has been effected. Upon the same principle, the remedy of divorce can be obtained only by an innocent party, and recrimination, if sustained, is a valid defense. So also when it appears that a non-resident plaintiff has moved into the state for divorce purposes only. Courts of equity are especially alert to enforce this principle in all applications for the extraordinary remedies of injunction, specific performance, reformation, cancellation, or rescission, and the like. The conduct of the plaintiff throughout the matters leading up to litigation will be carefully scrutinized. A typical case of injunction will serve for illustration. 256, Injunction. It has already been seen that the uttermost candor of statement is required for the plaintiff in his bill, especially when the application is for a preliminary injunction. There must be full disclosure of all material facts and documents. In a case where the testimony showed that a special circumstance set forth in the bill as a ground for jurisdiction were not the genuine reasons for prosecuting the suit, but that the plaintiff had an ulterior purpose not avowed, the bill was for that reason dismissed. A party who has influenced the action upon which liability was incurred cannot restrain such action by injunction. Infringement of a false trademark or label will not be restrained by injunction, nor of one used under circumstances of fraud upon third parties or upon the public. If a plaintiff seeks to enjoin a railroad company from building on his land upon the ground that he has not been paid, and it turns out that he bought the land in the interest of a rival company and as its representative, so no other purpose than that of obstruction and litigation, this principle will be applied to defeat the discreditable scheme. But the fact that the plaintiff became a stockholder in a railroad company in the interest of a rival company for its purposes does not dissettle him to the assistance of the court in enforcing a mandatory injunction. His statutory right as stockholder to the inspection of the register of stock and bondholders. Upon the same principle, where the majority members of the lodge filed an injunction billed to reclaim their appropriate shares for the lodge fund upon the ground that the separation of the lodge from the general order had deprived them of the benefits to which, as members of the order, they were entitled, it was held that the severance which formed the basis of the equity invoked must appear to have occurred otherwise than by their own fault, inasmuch as the members were responsible for the series of inequitable proceedings which led to the separation, including a fraud upon the court itself in procuring a receivership of the lodge funds upon false charges. The court could not recognize any rights deduced from such proceedings and dismissed the bill. An injunction bill prayed the removal of buildings extending by mistake a few feet over the plaintiff's line. A strip of land was comparatively valueless, except for purposes of litigation. The manifest object of the proceeding being to extort an exorbitant price from the land, the application was refused as oppressive. Mandatory injunction to remove an obstruction from a drain was refused, the plaintiff having caused an increase in the volume of drain water. An injunction to restrain a nuisance will not be granted to a party committing the same nuisance. A bill to remove a cloud from title was dismissed, the title being based upon an inequitable acquisition of the ward's property by a guardian. Next section, 258. Common law analogies. Extirpe causa non obitur actio, in peri delecto peri est condition defenditis. All laws as well as all contracts may be controlled in their operation and effect by these general fundamental maxims of common law, viz. No one shall be permitted to profit by his own fraud, to take advantage of his own wrong, to found any claim upon his own iniquity, or to acquire property by his own crime. If a legatee willfully murders the testator, although no statute has enacted the forfeiture, these principles will prevent his reaping the fruit of his crime. If the assignee of a life insurance policy has murdered the assured, his crime defeats his recovery. If the loss happens through a fault of the assured, the insurer is not liable, whatever may be the terms of the policy. The same principle is equitable familiar application in cases ex contractu. In a suit for a breach of contract resting on mutual independent covenants, the plaintiff, to succeed, must have kept his covenants. No contract or claim can be enforced founded on a violation of law or contra bono mors. No person can recover for a breach of contract occasioned by his own fraud. Nor can an action be maintained upon judgment maintained by fraud, even though the fraud is such that it cannot be proved without restraining questions already adjudicated. An action by a depositor to recover from a bank money paid out on raised checks will be defeated by proof that the fraud was facilitated by the plaintiff's negligence. Next section, 259, qualifications. Number 1, the unconscientious dealings charged upon the plaintiff must be conformed to his conduct in the matter before the court and not extended to matters eluded. The iniquity which deprives the suitor of his right is not general depravity, but wrongful conduct in a particular transaction. 2, when the transaction has been in effect a fraud upon public policy, which would be defeated by allowing it to stand, relief may be given against it, notwithstanding the plaintiff's participation. Thus, relief has been given against a gambling or usurious contract. On the other hand, an illegal contract will be enforced when public policy requires it. 3, relief may also be granted when a plaintiff, although precipice, has acted under undue influence, such as may arise from circumstances of iniquity between the parties, but this iniquity must also be so pronounced that the parties cannot be said to be in pari delictu. The mere fact of a relation between them of attorney and client will not accept the case from the general rule. Number 4, in some cases after the transaction has been fully completed and the money contributed has passed into other forms, a partner or agent in whose hands the profits are found cannot refuse to account for them to his co-partner or principal upon the ground that the illegal character of the original contract. And 5, the marriage status being on a different footing from contracts generally, a party may be relieved from his vowed marriage, although fully aware of his invalidity when contracted. Brings us up to the next maxim, or the last maxim in this section, 260, number 6, equity aids the vigilant. Now we'll jump to another book. Going now to Corpus Juris, section 163. That's page 207 in the PDF or page 180 in the book. Corpus Juris. Corpus Juris, page 207 in the PDF. That's page 180 in the book. That's section 163, number C, letter C. He who comes into equity must come with clean hands. Number 1, in general. The maxim that he who comes into equity must come with clean hands, or is frequently expressed, that he who has done inequity shall not have equity, or that he who has done iniquity or has not done equity cannot have equity, is of an ancient origin and broad application. It is the expression of the elementary and fundamental conception of equity jurisprudence, and although not the source of any distinctive doctrine, It furnishes the most important and universal rule affecting the entire administration of equity jurisprudence as a system of remedies and remedial rights. This maxim expresses rather a principle of inaction than one of action. It means that equity refuses to lend its aid in any manner to one seeking its active interposition who has been guilty of unlawful or inequitable conduct in a matter with relation to which he seeks relief. Next, 164, number 2, cognitive maxims. This maxim is cognate, which declares that he who seeks equity must do equity, and one of the converse of the other. The clean hands maxim has been said to be more efficient and restrictive of the two. The maxim now under discussion includes within its operation several others frequently acted upon in courts of equity, among them being the following. No action arises out of a fraud or deceit. A right cannot arise from anyone out of his own wrong. Where both are equally in the wrong, defendant holds the stronger ground, or the wrong defendant holds the stronger ground. Extirpity causes actio non orbitur, ex dolo malo non orbitur actio, jus ex injura non orbitur, in pari delecto portior est conditio, defendant detendus. Forgive my Latin. Next section, 165, number 3, nature of unconscionable conduct, A, general. Maxim operates so as to exclude aid or deny relief, or to form conduct which is fraudulent, illegal, unconscionable. The raised conduct need not be necessary to be of such a nature as to be punishable as a crime or actually fraudulent or constitute the basis of legal action. Any willful act in regard to the matter in litigation which would be condemned and pronounced wrongful by honest and fair-minded men will be sufficient to make the hands of the applicant unclean. The exclusion of the plaintiff from the particular favors of the court of equity equally results where the conduct has been unconscionable by reason of a bad motive, or where the result of any degree induced by his conduct will be unconscionable either in the benefit to him or to the injury to others. Restitution has been compelled of property received under an illegal contract not involving moral turpitude. Next section, 165, B, innocent and willfulness. The party entirely innocent of is, of course, not barred from relief because of the misconduct of others, although his rights have been associated with theirs. The maxim refers only to willful misconduct. The maxim must be morally reprehensible as to the knowledge as to known facts, but this means no more than free and deliberate action with knowledge of the facts. It does not require conscientiousness of the illegal or immoral nature of the act. Next section, 167, C, fraud against third persons. On the basis of maximum relief is sometimes refused where a stranger is the sufferer from the misconduct, and although the defendant is himself a guilty participant therein, and may indirectly profit by the refusal of the court to act. Thus, equity will not aid persons to get relief from situations which result from the conveyance of a property and fraud of creditors. It will not be enforced to secret trust by compelling a fraudulent grantee to reconvey, nor will it require such grantee to account. Same rules apply in the case of other devisees to defraud creditors. Not only is the fraudulent conduct debtor denied relief, but is also the fraudulent grantee when the latter comes into equity as to assert his claim. In the same manner, under a great variety of other circumstances, equity has refused to aid other parties where both are participants in transaction as fraud of the third person, either to carry out their arrangement, to set it aside, or to relieve in any way with reference to it. Next, 168D, similar but distinct misconduct. Relief has often been denied because plaintiff seeking relief against the misconduct of another has been guilty himself of similar but disconnected acts, although in a lesser degree. Next section, 169E, conduct with respect to suit. one may be barred from relief by misconduct with reference to the suit itself. Thus, equity will refuse to protect one who fails to make a full and free disclosure of all the facts relating to his case. And it has been held that, irrespective of the doctrine of res adjudicans, equity will not aid one who has sought the same relief in separate actions on grounds so inconsistent as to evince a lack of candor and clean hands. Section 170, number 4, parties bound. The maxim opposes itself alike upon whose defense and one whose prosecutes a suit in equity, but has been held not applicable to one who by interpleader. It applies to a corporation as well to as an individual. Next, 171, number 5, objection on court sui sponte. The unconscionable character or transaction between the parties need not be placed by defendant. Whenever it is disclosed to the court will of its own motion apply the maxims. It does not matter at what state of the proofs or in what order the lack of clean hands is discovered, but where the defendant who is guilty participant in the transaction by a legal slip loses his opportunity to disclose its turpitude, he will not as a matter of favor be permitted to do so. Next, 172. Number 6, limitations of rule. A, in general, this maxim has its limitations. It will not be allowed to work injustice and wrong. In its application, regard should be had for the doctrine that the fraud without injury is usually not available as a defense in equity. In some cases where plaintiff's misconduct had been directed against defendant relief has been given by imposing a condition of such a character as to eliminate the intended wrong, and a party purging his conduct as far as possible has obtained relief. Next, 173B, relation of misconduct to subject matter of suit. Misconduct which falls within the maxims must have infected the cause of the action so as to entertain it would be violative of conscience. It must relate directly to the very transaction concerning which complaint is made, and not merely in the general morals and conduct of the person seeking relief. The party is not barred from relief because the misconduct not connected with the matter in controversy, and this is true although the misconduct may be directly connected with the subject matter of the suit. The party may have relief as the transaction in itself untainted, although the title of the subject matter may have originally grown out of the wrongful acts not connected with the present controversy, as where the new transaction is based upon a valid consideration in which the original illegal or otherwise irregular transaction is merged, notwithstanding that such illegal or irregular transaction may appear in the course of the proceeding. One does not always forfeit a right fairly acquired by subsequent misconduct connected with therewith. Inequitable conduct in regard to the proof of some item in fact and in a transaction does not preclude plaintiff from obtaining the relief sought as to other terms. Next section, 174. C, a relation of misconduct to defendant. In the absence of any other equity arising against plaintiff, the general rule is that the misconduct must be so connected with the subject matter as to affect the equitable relation between the parties. But there may be cases where relief may be refused, although defendant was not concerned in the plaintiff's misconduct, as in the cases already considered of similar but distinct misconduct in the parties of the plaintiff and cases frauds upon third persons. Next section, 175. D, where public policy requires intervention. Maxim being one founded on public policy may require its relaxation, even when the parties have been found to be in pari delicto. Relief has at times been awarded on ground that the particular case public policy has been found to be the best conserved by that course. 176. E, conduct of adversary. The conduct of the other party may be sufficient to prevent the maxim from being applied, as where plaintiff's misconduct towards defendant was invited by him or waived. The courts inclined to measure the comparative guilt of respective parties and extend relief to those who is comparatively innocent. This situation has usually been presented in cases in which the wrongful conduct of the party seeking relief has arisen through undue influence arising from a trust relation of the parties, through mental weakness, threats, fears, or oppressions, and like circumstances which have been regarded as sufficient measurably to excuse the wrongful conduct involved. Section 177, number 7, applications of rule. A, in general, it is not always easy to apply the abstract principles of the maxims to a particular case because its limits are ill-defined. The circumstances under which it is invoked are necessarily an infinite variety. Of course, the doctrine has no applications where the facts do not show a cause of unclean hands. The most direct application of the maxim is the uniform refusal of equity to assist in one seeking its aid to enforce and carry out its fruition a transaction with respect to which the plaintiff's hands are unclean. The effect of the maxim is to the court of equity, which leaves the guilty party seeking its aid where it finds him. Not only does equity refuse to aid or enforce such a transaction, but where it has been in whole or in part carried out, equity refuses to undo it on the application of the guilty participant and refuses to relieve him from the legal liabilities or other consequences of his misconduct. That the party has no remedy or no adequate remedy at law does not prevent the application of the maxim, nor is it binding force destroyed by legislation which enlarges the jurisdiction of the courts of equity. Next, particular applications. This doctrine of unclean hands is a bar to equitable relief and has been applied in a great variety of cases, including those relating to trademarks and unfair competition, injunctions, specific performance, cancellation of instruments, subrogation, divorce, mandamus, where such proceedings is considered an equitable action. This maxim aids in the establishment of the doctrine of laches. Next, 178, B, illegal transactions. To the extent and within the limits discussed elsewhere in this work, the maxim excludes from the court of equity either party to a transaction tainted with any form of illegality, either to enforce it or to obtain relief against it, or one seeking to protect a right operating against public policy. A court of equity in one state will not lend its aid to the consummation of a transaction in another state in violation of the laws thereof. An illegal contract cannot be enforced either at law or in equity, and consequently this maxim is not needed to defeat relief in respect to such contracts. Would take us into this book, into the next maxim, which ties in with this one. Now we'll go to another book. We'll go to BizFam, section 41, page 264 in a PDF, or page 70 in the book. Section 42, that's page 264 in a PDF, or page 70 in the book. 42, number 6. He who comes into equity must do so with clean hands. This maxim is also expressed, he that hath committed inequity shall not have equity. Thus a party who seeks to set aside a transaction on the ground of fraud must himself be free from any participation in the fraud, and if he desires relief in equity, and on the same principle, equity will not lend its aid to assist in gambling transactions or to enforce penalties, or to aid in the harsh assertion of legal rights, or to set aside a conveyance executed to defraud third parties. And the court will sometimes act sui sponte upon the same principle when one of the several confederates to the fraudulent transaction has acquired the result of the fraud Equity will not aid the others in obtaining their share of the spoils. About the earliest illustration of this doctrine is almost transitional in the famous case of the highwaymen. Lord Kenyon once said, by way of illustration, that he would not sit to take an account between two robbers in Howells Hill. It was been questioned whether the legend in regard to the highwaymen did not raise from that saying. It seems, however, that the case was a real one. The highwayman did file a bill in equity for accounting against his partner, but the bill, it is needless to say, was promptly dismissed, and moreover the plaintiff's solicitors were summarily dealt with by the court as for a contempt in bringing such a case before it. Of course, this maxim only applies to the particular transactions under consideration, for the court will not go outside the case for the purpose of examining the conduct of the complainant in other matters, nor questioning his general character for fair dealing, nor is it every prosecution of an unfounded claim that will bar a man from coming into court of equity. There must be willful misconduct in regard to the matter of litigation. It has been held in some cases that equity will not necessarily refuse its aid simply because the fund or other subject matter in respect of which the relief is asked may have been originally created by an illegal transaction. Instances which has been found in Sharp versus Taylor, Brooks versus Martin, and in other cases, English and American, cited in the note. See footnote 6. But the doctrine in Sharp versus Taylor and the kindred cases is not to be extended. The whole subject was reviewed by Mr. Justice Pickwill in McMullen versus Hoffman, where the distinction was thus expressed, quote, in the case before us, and the cause of actions grows directly out of the illegal contract of the court distributes, and if the court distributes the profits, it enforces the contract which is illegal. But where A claims money from B, although due upon an illegal contract, and B acknowledges the obligation and waives the defense of illegality and pays the money to a third party upon his promise to pay it to A, the third party cannot successfully defend an action brought by A to recover the money by alleging that the original contract between A and B was illegal. This is the principle decided, and we think correctly decided, and the case is cited. Next paragraph, unquote. Under the same maxim, too, fall cases where equity has refused its aid to unconscionable demands or defenses and was left the parties to their relief at law. And that takes care of BizBam. So we'll do Snell next, section 6, page 71 in the PDF or page 42 in the book. Snell next. Number 6 in Snell. 42 in the book or page 71 in the PDF. Number 6 has an illustration of the second of the three kindred maxims, viz., he who comes into equity must come with clean hands, may be cited Overton versus Bannister, in which this maxim received a very pointed illustration. There an infant, fraudulently concealing his age, obtained from his trustee part of a sum of stock to which he was entitled on coming of age. And when of age, a few months after, he applied for and received the residue of the stock. Then afterwards, a suit was instituted to compel the trustee to pay over again the portion of the stock improperly paid during minority. But the court held that the concealment of age was a fraud on the part of the infant, and neither himself nor his assignees were allowed to enforce repayment by the trustees of the stock paid during the minority. The rule must be understood to refer, of course, to willful misconduct in regard only to the matters in litigation, and not to any misconduct, however gross, which is unconnected with the matter in litigation and with which the opposite party in the cause has no concern. Doctrine expressed, number 7, the doctrine expressed in the third of the three connected maxims is delay defeats equities, which is the next one, really. So let's finish that one up since we started on this short. Doctrine expressed in a third of the three connected maxims is delay defeats equities, or as it is otherwise expressed, equity aids the vigilant, not the indolent, may be briefly summed in the language of Lord Camden and Smith versus Clay. Quote, in a court of equity which is never active in relief against conscience or public convenience, has always refused to aid its stale demands where a party has slept upon his rights and acquiesced for a great length of time. Nothing can call forth the court into activity but conscience, good faith, and reasonable diligence, unquote. And it may be added that even a comparatively short period of delay, not satisfactorily accounted for, also tells heavily against the plaintiff in equity. Now we'll go to Gibson's. Section 42, page 62 in the PDF, or page 36 in the book. Page 62 in the PDF, 36 in the book. Section 42. He who comes into equity must come with clean hands. This maxim declares that a complainant who has been guilty of unconscientious conduct or bad faith, or has committed any wrong in reference to a particular transaction, cannot have the aid of the court of equity in enforcing any alleged rights growing out of such a transaction. The court of equity was regarded by the ecclesiastical chancellors as a temple into which none could come except those who had clean hands and pure hearts. In the origin of the jurisprudence, the theory was adopted that a court of equity interposed only to enforce the requirements of good conscience and good reason as to matters not equitable, determinable in the law courts, and its interposition being demand a matter of grace. It would not be exercised in favor of a person whose conduct in the matter he had complained of had been unconscientious or in bad faith, or who had violated any of the principles of equity and righteous dealings, which the court had been constituted to enforce. But the operation of the maxim confined to misconduct connected with a particular matter in litigation, and does not extend to any misconduct, however gross, which is unconnected with and with which the defendant is not concerned. Under the operation of this maxim, the complainant must show that the transaction from which his claim arises is fair and just, and there is nothing unconscientious in his conduct relative thereto, and that the relief he seeks is equitable and not harsh or oppressive upon his defendant. Harsh or oppressive upon the defendant. Harsh or oppressive upon the defendant. Hence, a specific performance will be refused when the complaint is obtained the agreement by sharp and unscrupulous practices, by overreaching, by concealment of important facts, by taking undue advantage of his position, or by any unconscientious means, or when the contract itself is unfair, one-sided, unconscionable, or affected by any other such inequitable circumstances, or when the specific enforcement of agreement would be oppressive upon the defendant, or would in any other manner work an injustice. So if a contract is affected with fraud or has a fraudulent purpose, none of the parties to such fraud can have the assistance of the court either to compel the execution of such contract, or to have it canceled, or to have the property or interest transferred thereunder restored. Equity will leave such parties where they have placed themselves and will refuse all affirmative aid to either of the fraudulent participants. It is on this principle that a court of equity is always shut against a debtor, and when he seeks to recover back property he has conveyed to hinder, delay, or defraud his creditors. Ex dolo malo non orbitur actio, or no right of action arises out of a fraud. agreements and transfers and consideration which is based on the violation of chastity or in compounding a felony or on gambling or on a commission of any crime or on any breach of good morals are all deemed illegal, and no participant therein can get any relief in a chancery court, whether the relief sought is an enforcement of the agreement or a rescission of it in pari delicto portore est conditio defenditus, or where parties are equally and wrongly in the wrong condition of the defendant is the stronger. Let me repeat that. Where parties are equally in the wrong, the condition of the defendant is the stronger. But where the parties are not in pari delicto, where public policy is promoted thereby, the more excusable of the two may be granted relief by the court setting aside the agreement and restoring him to its original position. The Court of Chancery will not enforce a usurer's contract even when the defense of usury is not made, but will relieve against usurious contracts and will also restore money or property lost upon any game or wager. That takes care of my friend Gibson. Now let's go to my friend Pomeroy. Pomeroy, section 397. That's page 723 in the PDF, 723, or page 656 in the book. Section 4, he who comes into equity must come with clean hands. Section 397, its general meaning. This maxim is sometimes expressed in the form, he that hath committed iniquity shall not have equity. Like the one described in the preceding section, it is not, in its ordinary operation and effect, the foundation and source of any equitable state or interest, nor of any distinctive doctrine of equity jurisprudence. Is rather a universal rule guiding and regulating the action of equity courts in their interposition on behalf of suitors for any and every purpose, and in their administration of any and every species of relief. Resembling the former maxim in its respect, it differs from that principle in some most important essential features. In applying the maxim, he who seeks equity must do equity, as a general rule regulating the actions of courts, it is necessary to assume that different equitable rights have arisen from the subject matter of transaction, some in favor of the plaintiff and some of the defendant. And the maxim requires that the court should, and the price or condition of its enforcing the plaintiff's equity and conferring a remedy upon him, compel him to recognize, admit, provide for the corresponding equity of the defendant, and award to him also the proper relief. The maxim does not assume that the plaintiff has done anything unconscientious or inequitable, much less does it refuse him all relief. On the contrary, it grants to him the remedy which he is entitled, but upon condition that the defendant's equitable rights are protected by means of the remedy to which he is entitled. On the other hand, the maxim now under consideration, he who comes into equity must come with clean hands, is much more efficient and restrictive in its operation. It assumes that the suitor asking the aid of a court of equity has himself been guilty of conduct in violation of the fundamental conceptions of equity jurisprudence, and therefore refuses him all recognition and relief with reference to the subject matter transaction in question. It says that whenever a party or who, as an actor, seeks to set the judicial machinery in motion and obtain some remedy, has violated conscience, good faith, or other equitable principles in his prior conduct, then the doors of the court will be shut against him in limine. The court will refuse to interfere on his behalf, to acknowledge his right, or to award him any remedy. Next section, 398, is based upon conscience and good faith. The principle involved in this maxim is merely the expression one of the elementary and fundamental conceptions of equity jurisprudence. We have seen that in the origin of the jurisdiction of the theory was adopted that the court of equity interposes only to enforce the requirements of conscience, good faith, and with respect to matters lying outside of, or sometimes perhaps opposed to the law, the action of the court was, in pursuance of this theory, in a certain sense discretionary, and the terms discretionary and discretion are still occasionally used by modern equity judges while speaking of the jurisdiction and remedial functions. Well, whatever may be in the strictly accurate theory concerning the nature of equitable interference, and the principle was established from the earliest days, while the Court of Chancery could interpose and compel a defendant to comply with the dictates of good conscience and good faith with regard to matters outside of the strict rules of the law, or even in condition to those rules, while it could act upon the conscience of the defendant and force him to do right and justice, it would never thus interfere on behalf of the plaintiff whose own conduct in connection with the same matter or transaction had been unconscientious or unjust, or marked by want of good faith, or had violated any of the principles of equity and righteousness dealing which it is the purpose of jurisdiction to sustain. While the Court of Equity endeavors to promote and enforce justice, good faith, uprightness, fairness, and conscientiousness on the part of the parties who occupy a defensive position in judicial controversy, it no less stringently demands the same from the litigant parties who comes before it as plaintiffs or actors in such controversies. Which brings in the other maxim, equality is equity. This fundamental principle is expressed in the maxim, he who comes into the Court of Equity must come with clean hands, and although not the source of any distinctive doctrines, it furnishes the most important and even universal rule affecting the entire administration of equity jurisprudence as a system of remedies and remedial rights. See footnote 1 and A. Next section, 399, its limitations. Broad as the principle is in its operation, it must still be taken with reasonable limitations. It does not apply to every unconscientious act or inequitable conduct on the part of a plaintiff. The maxim considered as a general rule controlling the administration of equitable relief, in particular controversies, is confined to misconduct in regard to or at all events connected with the matter in litigation, so as it has in some measure affected the equitable relations subsisting between the two parties and arising out of the transaction. It does not extend to any misconduct, however gross, which is unconnected with the matter in litigation and with which the opposite party has no concern. When a court of equity has appealed to relief, for relief, it will not go outside of the subject matter of the controversy and make its interference to depend upon the character and conduct of the moving party, and in no way affecting the equitable right which he asserts against the defendant or relief which he demands. Next 400, illustrations, specific performance. I shall now give some examples to illustrate the circumstances under which this principle operates in the administration of equitable relief and the manner in which it is applied. The first instance which I shall mention is found on the familiar doctrine which controls the equitable remedy of specific performance of contracts. A contract will be perfectly valid and binding at law. It may be of a class which brings it within the equitable jurisdiction because the legal remedies is inadequate. But if the plaintiff's conduct in maintaining it or in acting under it has been unconscientious, inequitable, or characterized by bad faith, the Court of Equity will refuse him the remedy of a specific performance and will give him to his legal remedy by action for damages. It is sometimes said that the remedy of specific performance rests with the discretion of the court, but rightly viewed, this discretion consists mainly in applying to the plaintiff's the principle. He who comes into a court of equity must come with clean hands. Although the remedy under certain circumstances is regulated by the principle, he who seeks equity must do equity. So in other words, the discretion is nothing more than the discretion of the judge is bound by the railroad tracks in which he is riding, and it goes no place other than where the tracks are, and the tracks are the principles or the maxims that he must adjudicate upon. Continuing on, the doctrine thus applied means that the party asking the aid of a court must stand in conscientious relation towards his adversary, that the transaction for which he from his claim arises must be fair and just, and that the relief itself must not be harsh and oppressive upon the defendant. I'll tell you, that's an example of the mortgage foreclosure today of the at-law contract that you sign where they got the right to foreclose on you and then get you for a deficiency judgment on top of that and then force you into bankruptcy and take everything that you got and clean your clock. But why would you want to go into the at-law side when you can't enforce any equitable rights there? Where if you did come in and invoke equity, you wouldn't be able to, the plaintiff wouldn't be able to take everything from you because you would have to have rights that were recognized by him, and it was only responsible for the amount that you actually truly owed, not upon everything else and taking it all from you. Stay out of those courts over there. We're in the wrong courts. We have no power there. The only power we have is in from equity. Continuing on, by virtue of this principle, a specific performance will always be refused when the plaintiff has obtained the agreement by sharp and unscrupulous practices, by overreaching, by concealment of important facts, even though not actually fraudulent, by trickery, by taking undue advantage of his position, or by any other means which are unconscientious, and when the contract itself is unfair, one-sided. And I might want to add there, just about everything that you sign today, you don't read, and it is all strictly one-sided, and you're not getting your side represented because you want the quick fix, the microwave fix of the thing now, rather than sit there and negotiate and tell them that it's an unconscionable contract. We need to be clearing out that defect by delaying the immediate need for what you're going after and correcting the contract. And you wouldn't be wound up in court, them taking and cleaning your clock. One-sided, continuing on, unconscionable or affected by any other such inequitable feature. Inequitable feature. None of these debtor-creditor contracts have any equitable features in there because they've taken away all your rights. And who put their name on the stinking contract? You did. And then when you can't pay your mortgage, you complain, I can't pay my mortgage, and they take everything from you per the contract which you agreed to, and then you say it's fraud. Let's get real here. You agreed to everything they're doing to you. In fact, you gave them the power to do it. Why did you do that? We all must be idiots, and believe me, I sign my name on those things too. Inequitable features. And when the specific enforcement would be oppressive upon the defendant or would prevent the enjoyment of his own rights or would in any other manner work injustice. Folks, the only way you're going to get this stuff is in equity, not at law. Stop invoking the debtor-creditor side by signing these contracts. These contracts automatically invoke the at-law side. You've made the choice. You made the choice for the at-law. And you can't complain what you got. Don't do that anymore. Don't make these unconscionable contracts. Don't sign your name to them. Form trusts, not debtor-creditor contracts. Don't get yourselves into these messes. You won't have to be in court. Learn how to operate a trust, administer a trust as a trust is administered. Do not do commerce. Stay out of commerce. Stay out of that law courts. Can't win there. Continuing on, this application of the principle, better perhaps than any other, illustrates its full meaning and effect, for it is assumed that the contract is not illegal. For it is assumed that the contract is not illegal, that no defense could be set up against it at law, and even that a possession possesses no features or incidents which could authorize a court of equity to set it aside or cancel it. Specific performance was refused simply because the plaintiff does not come into court with clean hands. Get that one on them. Next section, 401, fraud. Another familiar illustration of the principle may be found on all cases where the plaintiff's claim is affected by his own fraud. Whatever be the nature of the plaintiff's claim and of the relief which he seeks, if his claim grows out of it or depends upon or is inseparated, connected with, or his own prior fraud, a court of equity will, in general, deny him any relief and will leave him to whatever remedies and defenses at law he may have. The maxim is more frequently invoked in cases upon fraudulent contracts. If a contract has been entered into through fraud or to accomplish any fraudulent purpose, a court of equity will not, at the suit of one of the fraudulent parties, a participus doli, while the agreement is still executory, either compel its execution or decree its cancellation, nor after it has been executed set it aside and thus restore the plaintiff to the property or other interests which he had fraudulently transferred. Equity will leave such parties in exactly the position in which they had placed themselves, refusing all affirmative aid to either of the fraudulent participants. The only equitable remedies which they can obtain are purely defensive. Upon the same principle, whether one party, in pursuance of his prior arrangement, has fraudulently obtains property from the benefit of another, equity will not aid the fraudulent beneficiary. Notice they're talking about a beneficiary, and they just mentioned arrangement. Will not aid the fraudulent beneficiary by compelling a conveyance or transfer thereof to him, and generally there are two or more have entered into a fraudulent scheme for the purpose of obtaining property in which all are to share. The scheme has been carried out so as all result of the fraud are in the hands of one of the parties. A court of equity will not interfere on behalf of the other to aid them in obtaining their shares, but will leave the parties in a position where they have placed themselves. (402) Illegality. Illegality. Another very common occasion for invoking the principle is illegality. A. Wherever a contract or other transaction is illegal and the parties thereto are in contemplation of law in pari delicto, is a well-settled rule subject only to a few special exceptions, depending upon other consideration of policy. A court of equity will not aid a participant criminis, either by enforcing the contract or obligation while it is yet executory, or nor by relieving him against it, by setting it aside, or by enabling him to recover the title to property which he has parted with by its means. The principle is thus applied in the same manner when the illegality is merely a malum prohibitum, being in contravention to some positive statute, and when it is mala in se, is being contrary to public policy or to good morals. Among the latter class are agreements and transfers, and consideration of which was violation of chastity, compounding of felony, gambling, false swearing, the commission of any crime, or breach of good morals. It should be observed, however, and to avoid any misapprehension and seemingly inconsistency in the decision, that there are agreements which appear at first blush to be founded upon immoral consideration, or to which would at one time perhaps been regarded as contrary to public policy, which courts of equity do not consider to be illegal, and which there will be therefore enforced if properly coming within their jurisdiction. This kind are some contracts made upon consideration of the improper cohabitation being terminated, and those providing for children born from such cohabitation. Next, 403, limitations, parties not in pari delicto. Upon the general doctrine stated in the preceding paragraphs concerning the effect of fraud and illegality upon the remedial rights of parties seeking the aid of equity, there are certain limitations founded mainly upon motives of policy, which require brief mention. Wherever a case falls within the limitation and not within the general rule, the court may give relief against the improper transaction, or may even enforce the obligation arising from the tainted agreement, at the suit of one of the parties thereto. First, that these limitations may be given in the following general formula, and all the others may be regarded as merely particular deductions or corollaries from it, assuming that a contract is fraudulent or against public policy or illegal still, where the parties to it are not in pari delicto, and where public policy is concerned as advanced by allowing either, or at least most excusable of the two, to sue for relief. Relief may be given to him either against the transaction by setting it aside and restoring him to his original position, or even in some cases by enforcing the contract if executory. The second limitation I cannot better state than in a carefully considered language of the present Master of Rolls, Sir George Jessel, in a very recent case. Quote, you cannot ask the aid of a court of justice to carry out an illegal contract, but in cases where the contract is actually at an end or is put to an end, the court will therefore, to prevent those who have, under the illegal contract, obtained money belonging to other persons on representation that the contract was legal for keeping that money. It does not follow that you cannot, in some cases, recover money paid over to third persons in pursuance of the contract. It does not follow that you cannot, in other cases, obtain, even from the parties to the contract, monies which they have become possessed of by representations that the contract was legal and which belong to the parties who seek to recover them, unquote. One of the parties to an illegal contract may therefore, in some cases, maintain a suit against a third person to recover money which, as the latter, has received under the contract. In order, however, that such legal relations may arise incidentally and collaterally from an illegal contract, the illegality itself must not be of a nature intrinsically immoral or evil. It must be an illegality resulting from motives of expediency or policy. In all the cases where a right of action arising collaterally from an illegal contract has been thus recognized and enforced, it will be found that the agreement was illegal because opposed to some statute or so-called public policy. Conclusion. Special rules contained in the foregoing paragraphs will serve to illustrate the meaning and operation of the principle. He who comes into a court of equity must come with clean hands, but they by no means exhaust its scope and effect. It is not alone fraud or illegality which prevents a suitor from entering a court of equity. Any really unconscientious conduct connected with the controversy to which he is a party will repel him from the forum whose very foundation is good conscience, A under that. I'm going to add to that good faith along with that. So now we have one more maxim to go. We'll pick up that one next time, which is the last one in the enabling maxim, or the restrictive maxims, excuse me. The last one will be equity aids the vigilant. I'd like to summarize what Bouvier says. Give you the quote. John Bouvier, Institutes of American Law, 1882, Volume 2, Section 3724, Paragraph 4. Love this here. Law is nothing without equity, and equity is everything, even without law. Just that one sentence there explains it right so well. The law is nothing without equity. Equity is everything, even without law. Those who perceive what is just and what is unjust only through the eyes of the law never see it as well as those who behold it with the eyes of equity. Law may be looked upon in some manner as an assistance for those who have weak perception of right and wrong, in the same way that the optical glasses are useful for those who are short-sighted or those whose visual organs are deficient. Equity, in its true and genuine meaning, is the soul and spirit of the law. Soul and spirit of the law. Positive law is construed, and rational law is made by it. John Bouvier, 1882. He knew and understood equity. So with that, let's open it up for Q&A. Press star 8 to raise your hand and get in the queue line. State your name, where you're from. Star 8.
Hey, CW, how are you this evening?
Hey, Darren. How are you?
Good, good. A lot going on. Matter of fact, I was up in the federal court this week, and but it was something very interesting that I was looking up. And actually, this was the only place, now I might be incorrect, it might be listed somewhere else, but when I looked at it, it really jumped out at me, and it's actually under one place, even the at law, even though we're not quoting anything at law, but even on the at law side really is the only place that even Congress gave the people the right to redress an injury, which the landmark case was right there in Florida under Mitchell v. Foster. And that's under, of course, a 42 U.S.C. 1983 action, which is described as a civil action for deprivation of rights. But very interesting in it, in the wording where it says, every person who's under color of any statute, ordinance, regulation, custom, usage of any state or territory, District of Columbia, subjects or causes to be subject any citizen of the United States or other person, so you could claim to be another person, such as even a state national, within the jurisdiction thereof, and the deprivation of any right, so that could even be a private right, privileges or immunities secured by the Constitution laws shall be liable to the party injured in an action at law, comma, suit in equity. I said, wow, that was interesting that it said a suit in equity right there on that redress. Now, the thing is, once again, that goes back to Gibson, I think, Section 62, that shows that the jurisdiction of the court is determined by what's on the record, and it's how we come into the court with our pleading. If we're coming in with an at-law, we're going in through that side of the gate, or if we're coming into a suit in equity, we're going in through that gate. But it was very interesting, and something that I'm trying to decipher, because the way that I look at it is that it's always it's like an infinity wall going down, and it's just like two different ball fields the way that I look at it. You have the at-law side, and of course you have the equities, exclusive and inherent jurisdiction. Now the thing is then it also said, it was also interesting, and you could relate because this is Florida, under the Florida Constitution, even under Article 2, Section 8, it talks about ethics in government, which to me was an oxymoron just reading that. But it does state, in everything that I've read, it says right there in that section, it says, a public office is a public trust. And it also goes in further and says the people shall have the right to secure and sustain that trust against abuse. So right there, of course, it's talking in equitable terms. Now the question is that when let's say a public officer causes a breach, which basically they traverse not only on the public side because they have exceeded what their special duties pertain to according to their sworn oath that they promise to uphold and keep, but they also traverse onto the private side against private rights of a particular party. So the question is where you're going after a public office, you want to, of course, you never want to commingle, but you still want to hold them accountable because their unclean hands or their bad faith, their acts of bad faith, has traversed over to the equitable beneficial right of a party. So how really should it be, I mean, just thinking out loud, where you really want to hold them accountable? Of course, you want to create a trust with them, even though you don't want to go to the public side, because at the at-law side, you want to stay totally on the private side, but it has to be the breach of the public trust that also came over and breached a private trust, too. It's kind of like a double-edged sword, is it not?
Yeah, the way Palmer looks at it and expresses it, I believe he said that, or it might have been Gibson's, that the public trust was for the body of the people as a whole and not individually. And the only way you're going to get the individual would be to have some kind of individual contract with that officer on your own private trust. And I don't think anybody does that. Nobody expresses that. Although there is a public expression, as a public as a whole, they are accountable to the whole public.
Correct.
But to get that individual one, I think you'd probably have to do a private trust against them, which nobody expresses a private trust.
Not yet.
Yes.
But if you go on further in that same section, okay, any public officer who breaches the public trust for private gain, and any person or entity inducing such a breach shall be liable to the state and all financial benefits obtained from such actions in a manner of recovery and additional damages. Blah, blah, blah.
Liable to the individual. It says liable to the state.
Correct. Right.
To get that person to be liable to you individually.
Oh, I understand. And it's just, what I'm seeing, though, I'm still seeing there's trust all over this, but that's a statutory trust they're talking about, because now you've got to make it a private.
Don't mix with, or like oil and water, don't mix with private trust.
Right. Now, but the interesting thing, what I did, and I think I might have brought this up before, and I'm just trying to find it here, but even in such terms, where was it? Hold on one second. Where we're talking malfeasance, misfeasance, and nonfeasance, and it still coerces right into the same terminology, because it talks about an evil act. It talks about exceeding a duty. It's on those same guidelines that we're talking about, and basically it's just saying that they have breached a duty. They have exceeded or have not done a duty, and typically where they're not doing a duty, that has to be where they're superseding and they have not uphold and support, which is their duty, and if they go beyond that, then they either haven't done it or they've superseded it, which they're not allowed to do pursuant to the grantor's request, which is the grantor would be the people.
Yes, as people as a public whole.
Right, on the public side. Right.
On a public trust.
So the question, I guess, well, it's not maybe not even a question. Maybe I'm just thinking out loud, and just correct me if I'm wrong. So what I'm doing is, let's take, for example, so I get a hold of their sworn oaths, which really, that's their contract. That's their legal title, and their contract is saying, I hereby have agreed to and consented to uphold and support. Now I'm going to claim the beneficial interest in nature of that oath, and saying, well, if it's found to be that you have unclean hands or have acted in bad faith, whether past, present, or future, then I have a right to extinguish that debt or extinguish that oath, because you are breaching the public conscience. But I don't want to traverse over to that public conscience.
I wouldn't be able to do that individually. You'd have to do that, maybe it's like on a public trust, the public would have to come at you or come at them for the public breach. Not as an individual. Understand. But
like
an individual can go for redress of his grievances in equity on a one-on-one individual against an individual basis.
Well, you can actually, but if you have multiple, let's say for an example where you have multiple parties, where let's say you have the mayor, the city commissioners, and let's say several cops. Well, you could all name them as co-trustees if they have basically breached the public trust, but they traversed and went over against your private rights and what you deem as property. And my property could be anything. It's what I declare it to be. And
it's really up as a privilege that the state would have to look and say, okay, yeah, you've been damaged, and then we're going to attack the wrongdoers here.
Well, quite frankly, I don't care what the state does. That's fine. That's a separate matter. What I'm talking about is I want to be made whole because they traverse onto my private rights, because I'm acting equitably, and I'm basically...
And you're going to have a private trust with that individual.
But I'm throwing scenarios just to be sure that it's being done proper. And basically, what I want to do, just hypothetically, of course, is just talking about where I think that oath plays a part if you claim the beneficial interest in it.
Well, I think the whole purpose of the statutes and codes is to get you to operate in a venue, to become a fiction, to where they're granting you the privilege, and the only thing you're concerned about over there in the public realm is legal titles. That's it.
Right.
To the exclusion of your beneficial rights.
Right.
And that's what I want to start. I want to start a beneficial rights movement. A beneficial rights movement, because the at-law argument in the public side is nothing more than an argument against the legal title to the exclusion of your beneficial rights. And in effect, you have no rights. Because you have granted privileges that you can argue all day long on, and it's still up to them because they granted them.
Don't even want to go there. I'm going on my unalienable rights. And that's on my creator.
Any rights, the rights of the real men and women, then we got to be in equity.
And that's what I'm talking about. And that's where I'm going.
And no magic words are going to get you into equity. There are no magic words or magic formulas that are going to get you into equity. You've got an equitable, cognizable claim, and you're pleading.
Right. You're singing to the choir. I agree 100% with what you're saying. And what I'm saying here...
And then you get enforceable substantive rights.
Right. And what I'm talking about is those sworn oaths, which I can claim a beneficial interest in nature on, because that shows that they were to perform a duty, but because they didn't, they traverse onto my private substantive rights. That's what I want to claim, that I have a right of that, because it shows that they were supposed to do a specific performance and failed to do that, which allowed them to traverse against my rights.
Oath. It's really not the oath. You could take any piece of paper, whatever it says on the piece of paper, it makes no difference.
But that's
once you put the overlay on top of that, or put that other piece of paper on there that is your equitable asset, and you've merged it, that becomes the thing on the top. It makes the thing on the bottom invisible. There's nothing on it anymore, because this is the new contract, so to speak. I don't like saying, but so people could understand it better.
Yeah, but you can claim it. Yeah, but you can claim it. You can claim it because you're taking a beneficial interest in that legal title, which I
haven't claimed it. I've expressed it as being equitable, and I've changed its character by withdrawing it, really, and redepositing it special.
Right. Follow that. I follow that 100% on that. But what I'm saying is really that could put. Let's just say you could put it into a favorable negotiation in your behalf if you wanted to use it, to say, listen, I will extinguish that legal title, which you'll be out of work. Or, we can settle this honorably, fairly, outside of that in a private agreement, as such. Just throwing an example out there. I think you know where I'm going with this. But what I'm saying is that really, because that signature is of good and valuable consideration. That's really what they've given of anything
Not
of value.
Really, because there isn't, under trust, there is no consideration necessary for trust.
Right, but the signature, it can go or not go But if they had given that signature, then there is consideration.
Asset, but that's not consideration. Consideration is all DC stuff. Because there's no consideration necessary to form a trust. So it's not valuable consideration.
Right, but it can go both ways, can it? Can it go both ways? It can and cannot have consideration, right?
A statutory trust could have a valuable consideration, but I don't want a statutory trust. I want a private one.
Right, I want a private one. I want a private one, but can a private trust have consideration too?
No consideration is necessary to form a trust, and I don't want to use consideration.
Okay, it's not necessary, but it can be. That's my point.
Okay, and it makes it a public trust.
Oh, you think because of the consideration would make it public?
Yeah.
Okay. All right. I just wanted to make that point clear on that. All right. Okay. All right. Okay. So you're saying the oath is really not that big a deal?
No, although I would use the oath to get them in a private trust. Yeah.
That's what I'm talking about. That's what I'm talking about. I'm pointing
out that the oath becomes nothing. It's because I turned it into a special deposit.
Yeah, but if I order it the extinguishment, they cannot be employed.
Well, that's a different scenario.
Ooh, yeah, but it's strong negotiation too.
Yeah, well, I understand your point. Yeah.
Okay. It's saying, listen, it's like, did you ever see the movie The Godfather, where he was talking about the big guy? He says, well, either your signature goes on the contract or your brains.
Yeah, well, so feel they can't refuse. Yeah.
That's what I'm talking about. It's just a negotiable standpoint. Just saying, here you go. I could either give you the rope or you could jump off the cliff. Take your choice.
When people understand the principles behind this stuff, they'll understand they've got all the power. They got all the power.
Oh, see, Dub, I tell you, it's just been a remarkable ride with the NPT group, and and I've been on the DC side for so long. I tried to explain this. I had somebody call me up this week, and he was trying to tell me, I'm told that I need. I said, your problem is, you want something easy. You want a cookie-cutter template. You want a cut-and-paste kind of thing. I said, you ain't going to get it. I said, I won't give it to you. I said, for the simple fact is if you can't defend this stuff, you will fall flat on your face in any court, and the judge will see right through you, or a special magistrate that does understand it if you can't defend it. And I said, you're looking for the easy way out. I said, there is no easy way out. You've got to understand it like the back of your hand.
And so those people who want that easy way out are doing no more than they're like cheating at class by stealing the answers to the test. You're cheating.
Right.
People, you're cheating by doing that.
I agree. I agree. You know what? I am so thankful for the lesson.
You want somebody to give you the answer. No, you must know the answer yourself. You can't take the test.
CW, it took me a good 6 months to really renew my mind on NTT. But now, even stepping back, I'm like, I see trust in everything. Everything I'm doing, whether I'm going downtown, talking to somebody, doing what, I see trust in everything.
Now I learned to stay out of the statutes and code realm altogether.
Right. It's a whole different ballpark. Now we're going to see where it goes, because I have filed my first suit. I'm excited about it. I can't wait to do it. I can't wait to see what the court's expression is, because the first thing the federal clerk said to me, and she's been there for years, goes, I never seen a suit in equity. That was the first thing she said. I said, well, you probably haven't, because there's only been about 100 of them filed since 1933. But that's really where all the power is. And she, and I was sure to enter the proper amount of exhibits, because the bill itself and your exhibits and your memorandums, that really tells the whole story of how it is. And the points that I stayed very tough on was what they'll always look at first is jurisdiction. That's the first thing they look at is jurisdiction. So I made the point of equity's exclusive and inherent jurisdiction. The other 2 points that I hit very hard was trustees' duties and trustees' liability, because there's no argument, regardless of what I'm trying to do or whether I'm trying to stop an action from the outlaw side. My purpose of being there in that court is for breach of trust only, and I'm here for the relief of such. Those are my strong guns. It's coming in because I'm coming in here for the breach of trust. That's it. I don't care what they have to say.
But a good point, which maybe needs to be brought out, is that unless you have some kind, it's almost presupposed here at NTT that you have litigation skills. If you don't have litigation skills, you need to get them first, because you're going to have to take this into court, because that's the only place where your substantive rights are going to be recognized and forced upon the other parties, is in the court of equities. You're going to have to go into court. You're going to have to learn how to do litigation. If litigation is not your bag, I'm afraid you're going to continue to be a slave. That's been a presuppose, which we never really expressed that so much on any of the calls, but I'm afraid you're going to have to know litigation unless we come up with some other way that it can be enforced. But I don't think so.
Let me add another point to that, CW. The thing is, myself, I've argued in every court except for federal appellate and U.S. Supreme, and the state courts to me are nothing, and the circuit courts, I mean, they're but there's still some people are very intimidated by this. And let me put it this way: I was in chambers this week with a federal judge with a track record. You should have seen this guy's in chambers office. It was bigger than my house. And it's somewhat intimidating. And he had a stenographer, and we were just doing a pretrial conference. That was all we were doing. This wasn't an equitable case. This is a different case. But a person that has not had the skills could be very intimidated. So that's why it's more imperative that you know this stuff inside and out. And even if you don't understand it, stay to your strong suit. Stay to the strong points. Always stay to your guns, which will take you through some times where you don't remember things. Take notes. If you ever notice a good attorney, he's always taking notes. He's always writing down certain notes, and he even highlights his notes before he even gets in court of what he wants to talk about and how he wants to address the issues. So it's very important to do that. Kind of have it's like if you ever watch a football game on Sunday, these coaches, both on the offense and on the defense, they have a pre-game plan, what plays they're going to run. And also, if the other side runs this, how am I going to counter it? Okay? And I think one of the biggest guns we have on our side is equity number 7, is equity, performs, and persona. Because you're going to get another party, unless they're an attorney, and not even an attorney that understands equity, you got them. You can hammer them on that by just knowing what we know now in NTT. I think I can hammer anybody in there, and maybe even have to educate the judge too.
Right.
But it's knowing what you know.
One other thing I'd like to point out too: the litigation skills is not that hard. You don't have to know everything there is to know about the outlaw side. You just need to know the rules to get you into the court to where you can express your pleading as being and invoking equity, and then from there on, you're on the equity side.
I think the whole thing is based on your pleadings, just like what Gibson says.
It uses the outlaw rules to get into the equity side, so that's the only drawback. That's like the gate. That's the gatekeeper. You got to go by the rules, and the rules are the outlaw rules. So
but I even see it by the pleading. But by the pleading itself, when you're filing a suit in equity, that determines the jurisdiction of that court.
Yeah, it does. I can't get if I don't know enough how to file the document and how to put the form down, they may reject the form before they even look at the pleading,
Right, but once again, what's your argument there? Is that equity looks past form and procedure to the intent and the substance of the grantor.
Yeah, but I have to go through the gate of at-law first, and the at-law gate will not recognize the substance. I got to get into equity. So I got a at-law gatekeeper there that unless he gets it according to form, process, and procedure, then he can't allow me into equity. Once I get into equity, then I think everything changes.
But we're not even quoting any rules on that side at all. We're invoking it. We're decreeing what side we want to go in. We're decreeing to the gatekeeper, hey, I'm going on this. I'm going to equity's gate over here.
Right. But remember, the rules have been merged both in equity and at law to where there's one set of rules that gets you into the court.
Well, the only thing is that what I did not even include. I mean, I included that this is a specially pleaded matter, but I didn't write in Rule 9. I didn't do that.
Right.
I just wrote it. I wrote it in, and the first thing I did, just what you just quoted from Belvedere, that's the first thing I put in there. So that's the first thing they're going to look at.
Uh-huh.
And it's kind of almost like what's known as you can put like a preamble in it, and but what I hit a lot on, like I said, was the trustee's liability, the trust accounting and specific duties, because that's really what they're going to be looking at, because you're claiming of something of a breach. And, of course, you have to give and I also put a section in there, a breach of trust. I put in a section of specific performance, because equity acts specifically. And it's just under my statement of facts, with also showing that, hey, the elements of trust have been established. They are established. Here it is. Here's the exhibits that prove that it has been established, and it's also has not been rebutted.
Right. The proof of the trust first, because you're going to claim a breach on a trust, you've got to prove that a trust exists first. So.
Right, and it's done by your exhibits.
Right.
That's the only way. Okay, that my only question was just on the oath kind of question.
To the pleading that proves your case. Or
Right.
else they'll say, I don't see a trust.
Right. Or you could be a funny guy and say, well, here, I got some glasses for you. What John Belvedere said. Belvedere said. But no, seriously, is that I think if you come in with a proper pleading, and I don't think it's really that hard, because why are you there in court to begin with? Well, I'm here for one thing, the enforcement of a specific duty, because there's been a breach because of a non-performance by the trustee. Now, of course, to start it out, you have to say, well, there is a trust. Here's the elements of the trust, which are the fundamentals, and here they have been established and they are existent, and here are the exhibits that prove that they do exist. Now that they exist, let's get into the specifics regarding the trust and the statement of facts that surround this issue and controversy.
Right. And that trust, that private trust, is one of equity's children in Section 25 in Gibson's, which is automatically cognizable in a court of equity. That invokes equity right there. You're pleading a private trust invokes equity.
And that's one of the
That's
first
how you
things.
invoke equity.
One of the first things is once again, is going in there is that there is no adequate remedy at law for breach of trust. And, because I used to always hear people.
In the exclusive head, which means that it excludes that law, the exclusive head means it's one of equity's children alone. No other place.
Right.
Oh, no other place in equity. No at law. It's exclusive. Trust, private trust, rests exclusively in the exclusive head of equity.
Right, because a court of law does not have subject matter jurisdiction.
Does not have jurisdiction, period.
And that's what they always look at is jurisdiction. Jurisdiction.
That law does not have jurisdiction over a private trust.
No, they don't. Right, at all. Right at all. Another section that I also put in there early is I talk about the maxims of equity as how they are firm principles applied in this exclusive jurisdiction in deciding cases before them. This is all I need. basically is what I'm saying. This is all I need, and here's why this is why I only need these.
Yes, if you take the way Phelps breaks them down, he's got 8 enabling maxims. He's got 6 restrictive. That's 14 maxims. And there are a couple extras that grow out of those. So we're talking maybe the max 20 maxims. That's all. Just 20 maxims that runs that whole court. I don't need the 63 million statutes and codes in the at law side.
Mm-hmm. Right. And you got to know what basically the inherent and exclusive jurisdiction is, and it's basically 2 principles that determines the equitable rights, the states and interests of the parties, and also it grants equitable remedies. That's basically what the exclusive jurisdiction does. Now, once you're there, then equity acts specifically in contrast to the rationale of law, which, of course, is its counterpart. And, of course, you're there for declaratory relief more than anything else.
Just as John Bouvier said, law is nothing without equity, and equity is everything, even without law. And it is the soul and spirit of the law.
Right.
In other words, equity is the creator of the law.
I did put a little section in my bill that what I declare as what my property is. And my property could be anything that I decree it is. That I have a personal interest, that I have a right to ownership of that. Because it's always about a right. You always have to be declaring a right in equity's jurisdiction. It's about a right. I have a right to this. I have a right to that. I have a right to this and that. They don't have a right to this. You know? It can still work both ways, but it's, you really can understand. And then once they're not answering, it's the Unclean Hands Act that shackles them down even further. Now, it's different if they have an equitable claim as well. But if there is no equitable claim there and they're coming in with unclean hands, that's shackling them down more, and it's building greater ammunition for your side, for your argument, which really isn't an argument at all, because it should be determined exactly just by what you're submitting into that court, saying, I should submit this and not say a word because it stands on its own merits.
Yes. Uh-huh. The motion is a speaking motion, and it's
right. I think what everybody should always focus on is always asking yourself is
equity sees, at law hears.
Exactly. But even more than that, going back, because I think a lot of times people are thinking about, well, how do I establish a private trust, and how do I just go back into Gibson, and you just have to look at the elements of
Gilbert's.
And it's basically intent, purpose, parties, and property or trust res. Once that's there, now it is established. Now you have established a trust. If one of these items are not there, you don't have a trust, so you don't have a claim. But once you've established the basic, the fundamentals, the elements of the trust, now you have it. Now you can proceed in trying to get them on the breach, which is done through the private agreement, which is also known as the indenture. Once you have that indenture and they fail to perform a specific duty as instructed, decreed, and commanded by the grantor / beneficiary or whatever status that you're taking, now there's the breach. There's your cause of action to bring them into a court, because there's an issue of controversy saying, I demanded you haven't done anything, I have no other way to do it except to bring you into this court and have the court demand you to do it.
Right.
That's it. That's my only question. Thanks, C-Dub.
Okay.
All right, buddy. Thanks.
All right, thanks, Darren.
Uh-huh.
Star 8, anybody to ask a question? Raise your hand. Get in queue line. Star 8. Who's next? Star 8.
Good evening, Christian.
Hi, who's this?
This is Susan in Alabama.
Hi, Susan. What's your question? How you doing?
I'm doing fine. I have a family member that has a private trust, and I may need to talk to you privately about this because it's kind of complicated. But is there any way a private trust can be changed when the person that created the trust has passed away?
All right. Well, we want to do what again?
I said there's a family member that has passed away several years back, and they created a private trust, and through an attorney and all, and the person that was put into this trust from this other individual, they are wanting to be able to do some changes on it. Is there any way that can be handled through the person that was put through the trust?
Well, I don't see how you could change the grantor's will and his intent after he's dead, because how else would his will and intent be accomplished?
Well,
whoever he named as beneficiary, that's who the parties are going to be.
Right, I understand that. But this person is wanting to change it at this person's death. The person that died and left is my mother, and it was her mother. She's wanting to change it because in case something happened to her.
Not her trust.
My grandmother put it in case something happened to my mother, that another family member would get
I would say unless in the indenture a power was granted to the beneficiary to modify the trust after death, it would not be possible.
So my mother would not be able to do anything about it?
No.
Okay.
I mean, if everybody died and then somebody else who's kind of come along and then changed somebody else's trust around, I don't think so. That would violate all trust laws. Whatever is the indenture is the law of the trust. And then when that party dies, then the beneficiary estate can't come back in and say, well, I'm going to change everything around the way I want it. No, it wasn't his trust to begin with.
Well, this has just come up today. So that's why I was wondering if my mother could do any changes on it.
It could change the trust intent and purpose to any way that he wanted, then that makes him the grantor of it. And he's not the grantor, he's beneficiary.
Right.
I don't think it's possible, unless he was granted some kind of power to begin with from the grantor.
Well, she was an only child, so that's why.
Doesn't make any difference. She's not the grantor, she's the beneficiary.
Okay. Well, that was my question. Thank you so much.
Okay. Star 8, anybody? Raise your hand, get in the question line, queue line. State your name, where you're from. Nobody? Got a clean board? Oh, I guess we can go home tonight then. Star 8, clean board. Anybody? Question? If not, I'm going to go rest. Star 8, anybody? Star 8, question, anybody? Going once? Star 8, anybody?
Hello?
Hello, who's this? Caller, you're unmuted.
Chicago?
Hey, Chicago, how you doing?
I'm all right. Christian, I had one question. And you mentioned earlier with the young lady that just came before me about being the beneficiary of an account. How do you recognize the position of being a beneficiary of, like, say, for instance, the Sesta K Trust, and knowing the difference between whether you're on the beneficiary side or the grantor side?
Within yourself?
Yeah, well, your beneficiary account, your account, I was told it was an exemption account, but I don't understand how to look at it as an exemption account yet. But Social Security is such the case.
We look at it as that's a trust account. What do we look at it now?
Right. So how do you decipher the difference between the two sides? I mean, there's a beneficiary side, and then there's a trustor side or a seller. But now the government is in place as the trustee. How do you manifest expression instead of construment?
Oh, that's in the past audios where we expressed trust, which was like in the beginning of 11/7 of 2009. We went over that, and we went over extensively when we went over the audios on the Gilbert's trust manual.
Oh.
Book. Basically how to express a trust, which is intent, purpose, party, specific, res, and a method of formation. The elements necessary to prove a trust. That's going to establish whether or not you're a grantor and who the beneficiaries, the parties are.
Okay, 2009. Okay, I have those.
Go through the audios, the ones that are talking about Gilbert's on trust, on the formation of the trust. That's the one.
Okay. What is that PDF that you were reading out of? How did you get a hold of the PDF that you were reading out of tonight? The Phelps?
Ask Faith to Trust. Skype her, and she'll send it to you.
Ask who?
Faith to Trust. Faith, Faith, the number 2, and Trust, Trust. Faith to Trust, Skype her.
Oh, I have to, okay. Faith the Trust Geiger. Did I just look that up online and just download it or something?
Oh, Skype.
Oh, Skype. Oh, Skype. Okay.
On the internet, Skype.
All right, that's all I had.
Yeah. Skype her, and she'll give you a copy of it.
Okay. Thank you.
Okay, all right. All right, anyone? Ask a question. *8. Raise your hand.
Christian.
Yes.
Hey, it's Dan.
Dan, how are you?
Oh, fantastic. And yourself?
Oh, still kicking.
Or as my dad would say, terribly fine. Anyways, a little while ago, you and Darren were starting to get into the rules. And I have a feeling that I've erred big time because in all of my pleadings, I was feeling the way Darren was expressing that since we're going into equity, it's got to be in the pleadings and blah 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 blah. And I've left out rules of civil procedure, blah 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 blah. However, you were expressing to Darren that those have to be in there.
Well, I would say you have to be operating by the rules.
Okay.
They say, it has to be of a certain type of pleading style, it has to be a certain way. Otherwise, if there's not some kind of rule, then everybody's doing everything all different.
So let's say under federal, you are wanting to come in under mistake. You would have to, Rule 9 is pleading special matters, and I think B is mistake. So you have to quote that.
He didn't say, although he put it in there, pleading special matters. But
see,
if he was stating special matters, then he really was going by the rules. So, but let's say he didn't put down Rule 9, but he still put down pleading special matters, which is Rule 9.
Okay, so we don't have to actually quote coming under Rule 9B, blah, blah, blah. You just quote the spirit of the law, basically. Like pleading special matters, that key phrase, coming under mistake, or pleading mistake under special matters. And that would be the same as pleading or putting in.
Well, that's one of those gray areas we don't actually know for sure just yet. do you have to put that rule down number-wise and then state the rule's meaning? Or can you just get away with putting the meaning in there and that gets you... That's one of those gray areas we're going to have trial and error to find that out.
All right. I think in my situation, I'll go back and I'll amend what I've done and just go ahead and state the rule and why I'm coming under that rule, because that seems to be what the other side does. They come in Rule 56 for summary judgment. They express the rule and express why.
Scenario, it's I think the way it looks like is that you're getting rolled over because you're not objecting to what they're coming at you with and not striking out what they're relying on, because they're not making any equitable claims, although you are, but you're not, say, striking the fact that they have no equitable claims.
And using discovery to get them to admit it.
Well, no, it's not discovery. They're not pleading anything equitable, I don't believe. They're just rolling over you on the at-law side, but to cut them all up, I would just motion to strike because they have no equitable claims. Destroy their evidence that they're relying on because their evidence is not equitable. Like, 12b-6, they failed to state a cause of action which relief can be granted. Well, change it around a little bit. It's like they've failed to state a cause of relief that relief could be granted. They don't have an equitable, cognizable claim against you. It can't. So there may be some other factors involved there too. But
I'm kind of feeling in some senses that since I didn't speak when I should have, equity's not going to allow me to, basically not going to allow me to speak when I, now, because they've already got the summary judgment against me. I already conveyed title, and here I am going to come back in and say motion to strike due to plaintiff not having authenticated evidence and failing to state relief upon which relief can be granted, non-cognizable equitable claim. Kind of went past that, kind of waived it at this point.
Yeah. Like you had your day in court, you failed to show, waived, and now you're coming back in and trying to correct what's done, which makes it harder to do.
Right, and it's not their fault, it's my fault, because I don't understand the rules of the game. I mean, I'll be quite honest, it's my first case ever, and here I am in the federal level.
So if there's anybody out there that's a paralegal type that knows more about federal, we need some people with some litigation skills that maybe could help on federal levels.
Now, I've heard you talk in the past about the O'Connor's book, and then in other conversations, the O'Connor's book, that's going to contain example forms and stuff like that. Is that correct?
Yeah, there's a CD with that gives you the actual forms, yeah.
Okay. I know that Night Train has a few on his website. And so I searched through, anybody interested, I searched on Amazon, and I was able to pick up a used book rather than over 100. I picked it up for like $7 plus shipping, or $3.99 plus for shipping.
Yeah, that's Federal Rules by Civil Trials O'Connor's. I got the 2000 edition, so you got 2010 now. That's great. And then the Federal Civil Rules Handbook by West. Those two books there on federal. Everybody should have that in the library. And then that evidence book. I have one of Florida and Federal Evidence Rules by Peter Nichols. Everybody should have a copy of that as well.
The one with the Florida rules are one.
Well, mine is Florida and federal. They make one, I think, in New York and federal, and California and federal.
Okay, you've spoke about that before on the previous calls too.
Yeah. It's Florida and federal, New York and federal, and Texas and federal. That's the three that they have under the evidence.
Okay. All right. Well, no matter what, even though the title's been conveyed, blah blah blah, I've kind of gone silent. That's still a mistake and ignorance of rights. So I should be able to create an equitable pleading, come back in, and say,
Now, it's like there's two things that may be happening. Either, maybe it all rests on one. It might not be that they have recognized equity. Now, that could be because maybe they didn't plead it right, or maybe they're just not recognized. It could be that the at-law side is rolling forward, and the reason why it's rolling forward is because you're not objecting and not striking out stuff that's because you're allowing it to move forward.
okay, I have objected.
That is what's rolling all along, and it's. I think you're doing something on your, or not doing something on your part that you need to be doing, or.
Oh, I completely agree. It's my lack of knowledge here that I'm suffering from. Not stopping me, but I'm suffering. Now, I have objected in the past to their, claimed relief and claimed my right to be, to not be punished by.
Yeah, but it's an objection, even with an SOI. Okay, so you object, that's on the record, but that doesn't do anything for the at-law side. Like you're not destroying their evidence that's attached to the complaint, which gives them the authority to move forward. So you'd put in an objection and a motion to strike their evidence because it's not an equitable claim. Now, if the plaintiff doesn't have any evidence then they have no cognizable or cause of action that's even valid in that law.
Yeah, I'm going to have to go back and destroy their evidence, destroy everything else that the foundation that they used to create that they created the comfort order off of, which the comfort order states that they don't have to respond to anything that I put in there that claims an interest or a right in the property. So it's kind of a circular deal there. Somehow I've come in and destroy all that.
Let's go back to the comfort order. The fact why that was issued. If that was issued the way it was, it may be that it looks like there's a frivolous claim because there's no proven trust because it was not recognized because this comfort order was that said that plaintiff doesn't have to answer to you. Now, why don't they have to answer to you? Because something wasn't done right, that court is not recognizing your equitable complaint. And I think that's the whole key that's allowing them to run forward, and you're not objecting with any legal claims that they're coming with, not objecting to the evidence and striking the evidence, and you probably can't because something is done from the beginning that they're not recognizing the equitable complaint, the bill in equity. Because if they say that the plaintiff does not have to answer, you should have a pro confesso and we won.
Well, would that hinge on the subpoena not being served?
Yeah.
So maybe I should go in and check out the rules because if I remember right, I remember seeing in there that I have up to 120 days after the counterclaim has been filed to actually cause the subpoena to be served.
And it also might be that you could have used on Form 285, the Marshall form, to actually serve the summons. Maybe that might have something to do with it too. How did you have it served?
Yeah, it wasn't served. Well, it was just a counterclaim stuck into the record, court record. There was nothing ever served personally.
Why?
Yeah.
Why? There was no service. There's no reason for the plaintiff to answer. There's no teeth in what you did.
Okay. All right. And in the marshaling form, you have to contact the marshal to see how much.
You got to file the equitable complaint or the equitable counterclaim. You got to pay the fee and get it served. It's got to be served through the court. And that way that clerk of the court starts the time clock clicking for 20 days for that party to respond. And when that party doesn't respond, then you can do the pro confesso. You've won. But if you don't do that, you just throw a counterclaim in there, go file it into the case. That plaintiff does not have to answer your counterclaim, and you get hit with a comfort order. You goofed up.
Yes, sir, I did. My fault. Okay.
There's no requirement for plaintiff to respond and answer your questions and your bill. And therefore, everything, it's like it's like you have a frivolous complaint, and the outlaw side keeps on rolling over you.
Or the points that I made were moot.
Well, if you didn't serve the counterclaim by through the court and paying the fee and getting it served by the proper way of serving it, say in federal by the marshal under the 285 form, then you've got no counterclaim. Probably the key to your whole problem.
Okay. Well, the motion that I've got stuck in there to, for the court to set aside the comfort order and basically allow me to come back in and amend my claim and cause subpoena to be served, that had no rules behind it. So they could even claim, like you were saying earlier, they're not going to be able to see that either, right? So even that's screwed up?
What's it based on? It's based on no proper filing of the counterclaim.
Right. No proper filing of the counterclaim is based on mistake. I never did say anything about, I never did mention any special matters or anything else in there, so it's not really pointing at a rule other than stating mistake. It's equitable because I'm going by the maxims.
So I put in some kind of amended complaint, or what? Amended what?
Basically a motion of mistake, and motion for leave to fix mistake, stating in there that I failed to recognize other parties' rights to be served due process, and then leave to amend the counterclaim and cause subpoena to be served.
Did you do it?
Yeah, it's filed in there. I'm waiting for an answer. I'm just a little concerned that since I didn't quote any rules, as you were saying earlier, that they don't even have to, that the blurry-eyed watchers are not going to see that and not going to grant that either.
Well, that's the gray area I'm not sure of. So
Right. I mean, there's at least 3 or 4 equitable maxims, the spirit of the equitable maxims in there. It's equitable on its face, but
the party who looks like they're in equity has not stated the rules specifically by number, but put the meaning of the rule in there because they put pleading special matters, and it looks like that worked.
Okay, see, and I don't have pleading special matters in there. I just have mistake. So that would be, 9B, but not stating a special matter.
Go back to the pleading special matters because that's my counterclaim. That's my trust.
Right. Right.
You get that trust filed in there the proper way, or you ain't got no trust claim. You ain't got no bill. You got to go back and correct that issue. You got to get the seed planted in the ground before it takes root. You can't have it, in a jar someplace. It ain't going to take root. Go back and correct the counterclaim.
Okay. Well, what I'll do is I'll see when that was actually filed, and then I'll check the rules again and see how long.
On the plaintiff to answer that counterclaim by the 285 form of the marshal.
Okay. I think I have 120 days to cause subpoena to be served.
How much is the fee for filing a counterclaim?
The filing of the counterclaim was free.
Hey,
the filing of the subpoena is free. It was just cost to have it served.
Delivery for the sheriff, or the marshal, to go serve the summons.
That's still a phone call away to find that out. I just got to call him and find out.
Get that thing served. You don't have a bill in equity until you get it served. And he doesn't have to answer until you get it served properly. Violating is processed by making accusations based on a frivolous claim.
What reference can I go and look at? What reference can you give me so I can go and look at and see, where that states in there you have to have it filed by the sheriff or somebody? Is that in the rules or,
Yeah, that's in the rules.
Okay. Because I looked and I didn't see anything on the face of the rule, on CornellLaw.com about having it served by the sheriff, but I'm wondering if that's because
I'll haul you into court and I sue you against something, and you can say that you never got served. What's going to happen to my case against you?
Toast.
That's what you did.
All right.
Correct the problem. Give the guy due process. Go file it according to what the rule says. Get the thing served so you can get the summons served to him, so he's got a duty to respond to your accusations.
Once that is done, since the counterclaim is already on the docket, do I need to refile the counterclaim again with notice that, obviously I have to send court notice that he's been served, but do I need to refile the counterclaim again? I don't think there's anything wrong with that.
I don't know. You'll have to check with somebody who would be up on that.
Okay. Let's see if I can find somebody to help me out that has federal knowledge. Okay, that's, and earlier when you were speaking with Darren, you were speaking about when you're putting stuff on the record, the thing that goes on top causes the thing underneath to become invisible. And you were starting to get into something real good there, but then the subject matter got changed. Could you get back into what you were going to get at in that, if you remember?
Yeah, I was trying to point out to the fact that whatever is underneath doesn't really matter, because it's what you put on top that counts. Because when I put it on top and I merged it, it became the new thing on the top, and the stuff below it became like invisible. It's like non-existence, because I've merged the two, my equitable asset that I put on top with the debt liability on the bottom. When I did that, they all became one, and since the equitable asset is the superior one, that's what stands as being the thing on top. So it doesn't make any difference what's underneath. It's like it became, the wording on the paper just disappeared. Because it was merged with the thing on top. And the equitable asset, as my special deposit, that was superior. The equitable estate is superior to the legal estate, but only in equity.
Yes, where the beneficiary is recognized.
Right.
It's the same principle.
At law title, the legal title is superior, but that's to the exclusion of the beneficial interest, which is not right. So if you're in equity, equity is going to look at it and say, hey, this legal title is inferior. So the inferior is swallowed up in the greater, which is the equitable. That's merger. So it's not merger because I put the one paper on top of it and I stapled them together. No, it's merger because it was my intent to be the two merged and they be extinguished as being the obligation of debt. And then I deposit that back to the trustee as a deposit.
Okay. Now, somebody on the chat group today was talking about niches on banks and banking. Have you ever heard of that book before?
Yeah, but that's all statutory. That's all statutory trust. That's all commerce.
Right. I know that they speak of special deposits and stuff like that in there. And when I've heard you speak of special deposits or non-negotiable, you talk about the bank officer's handbook. In comparison to those two books, the bank officers and Mishi's, they're equivocally the same, right? Both at law. Just
yeah.
giving you. Okay.
Really, they're both the same. But trouble is, you got to go by trust law, not by banking law. You know, it says in that Michi book that it said that, you know, if you just put executor on there, that was a special deposit. No. If you don't have the necessary elements in a formation of a trust, you don't have any trust or special deposit. So there's some missing pieces in there that you're only going to get through Gilbert's.
So it's like trying to use football rules to play baseball with? They're similar in, you know, the ball being
but I would
knocked back and forth.
imagine that if a guy wrote a book on it, he might know something what he's talking about, but, you know, there was just a few things mentioned, and I haven't looked at the book, so. But I can firmly go from what I do know from Gilbert's that I don't care whether you say you got a trust or because no specific words are necessary to form a trust. In other words, just because I put executor on there does not mean it's a trust. Gilbert's plainly points that out. It's only if you have the specific elements necessary that the law will recognize being a trust that there is a trust. And that means that special deposit has to be based on intent, purpose, parties, specific trust res, and a method of formation. Or else there's no trust, even if you say it's a trust.
And the records to back it up.
It's executor, or just because I say this is a trust deposit does not make it so. That's what Gilbert points out. It may be just some other look-alike or relation that is not truly a trust. And special deposits put in the bank under commerce are quasi-trusts. They're not true trusts. Because you didn't put the specific money in, recording the serial numbers of the specific bills that you used, and said, hey, I want that money back exactly with the same serial numbers. That would be a true trust. You have a quasi-trust. I put $200 in under a trust deposit, and I get $200 back out with some other type of serial number on it, although we're going to say that's a trust deposit. Technically not so. It's a tontine trust, a quasi-trust. It's statutory. So we've got to know what we're talking about, folks. And it's got to be based on facts. You can't just make a claim and say, okay, executor, I'll put executor on there and that's the way it's going to work. No, I'm afraid that's not a trust deposit. It better have intent, purpose, party, specific trust, res, and a method of formation. If it does, it passes the trust test, then I'd say you got trust. The special deposit is two things. Special deposit is a deposit of something for a safekeeping that you want it back sometime in the future. And you're going to get the specific thing that you deposited back out. That's a special deposit. Or a deposit of something made for a specific purpose. That's a special deposit.
Like Strawman put it so eloquently the other day, here's my pen because I want you to use either blue ink or write from this pen, or here's my pen, I want my pen back.
Yes. Sometime in the future I want my pen back. No trust words were necessary to form that trust. In fact, none of the parties knew that a trust was being formed.
And the lady that was calling up about the trust, the grantor having died, I've got a friend here that is actually dealing with the same issue that he came to me with. Grantor had died. The beneficiary is with an interest that others in the family were wanting to get at, and I told him that she could simply do, the beneficiary that is either declare among herself as holding that interest as trustee for somebody else, that makes her grantor trustee, or she could convey her equitable interest. Well, that would be conveying, or she could be.
She could form another trust with her interest in.
Yes, there you go, and protect it.
and then form her trust with any way that she wanted to.
Yes. It's not taking place of the old grantor and changing their intent and purpose.
Right, you can't change the old grantor's intent because then that would defeat all trust law. You can't go against that.
No. But you can protect your interest as beneficiary. You become grantor trustee or grantor beneficiary. And then your indenture becomes the private law firm, and you're in control now, and you can protect it in your trust.
Right.
So
but you only grant what you have at the moment.
Which brings us back to prior conversations when as soon as you sign that mortgage, that deed of trust, there are several things that happen right there. Number one, you're claiming you're taking ownership of the property, and at the same time conveying it over to somebody else. So,
well, you're doing a conversion. You're converting your title and giving a general deposit and getting rid of all your rights, and then you're getting a thank you receipt back with for your liability that you're incurring, and now you're liable for the fee to the lord that you made.
And that's an executor contract, right?
Well, you did a conversion on it, and you didn't know you were converting your titles. You made them beneficiary, who is lord, and then they got the right to take from you because you're the trust. You made yourself trustee, so that you owe them fees, taxes, for the use of the property that you had in your hand, but you gave it to them. You gifted it to them. You formed a trust. So you converted your equitable asset into a use. And now you owe the fee for the use. So you just turn yourself into a tenant on the land, a freeman. You're free to use the land as long as you pay your fees. You're a churl. A dumb one at that. And here you were beneficiary to start out with, and you turned a grant or trust, and you granted it into a trust and converted yourself into a trustee. But hey, they don't have to tell you what's going on. You're over the age of 21, legal age, so you can do the legal title stuff, whatever you want. And ignorance of the law is no excuse. So you gave them all your power, all your authority, all your force.
I hereby grant a security interest.
Now don't pay your use fees and see what happens.
Yeah. Or gain the knowledge, come to the age of majority, and correct your mistake.
Yeah, and don't do it again. Don't get in those invoking debtor-creditor contracts on the outlaw side, and then you won't be on the outlaw court side wishing you hadn't been there.
And don't fail to have the subpoena served upon the other side.
We're all learning, so we all make mistakes, but fortunately the mistakes can be corrected, especially if you do it timely so that the latches doesn't set in or the equitable maxim. You got to be vigilant. If you're not, you're going to lose your rights. Equity aids the vigilant. Correct it.
Okay, CW, that's the points that I wanted to hit and questions I wanted to get out, and we still got that gray area we need to figure out. So
yeah, there's always going to be a few gray areas until we get this figured out.
Right.
I think we've got the bulk of it down. So.
Okay. Well, I'll move forward on trying to checking to see how much time I've got left to cause this to be served, and then do it.
That everybody needs to become a better litigator. If you don't know anything about litigation, you better start learning.
And you suggest learning by just simply going and sitting in on court settings and watching the exchange back and forth?
I'd go get the rule books at the each venue, state court and federal court, and start looking at the rules. Start learning the rules.
Okay.
Get jurisdictionary. That's a good one there to start out with in state. Start learning about evidence. Start learning how the court really functions. And then get that start down a little bit. And I'd be looking at Gibson's right along with it because that's the equity side. If I would have known Gibson's along with litigation to start out with, that would have made my whole litigation a lot easier.
Okay, and I'll put those links to that Federal Rules of Civil Procedure book with the annotations and the O'Connor's book in the main chat. It's almost $200 worth of books brand new that I picked up for like $23 and some change to include shipping. Both, of course, used, but I'll put that in the main chat to help everybody else out. And then I can't think of anything else, CW. I think I'll go ahead and bow out. And once again, thank you.
Should get the CDs with that O'Connor's one because that comes with a CD with all the forms on it.
Okay. Yeah, I'll have to see because it never did mention anything in the description that I had the CDs. But if it doesn't, I'll do some looking around and see if I can't find it somewhere else.
All right, let me see. Maybe the CD was extra. No, I forget.
It's highly possible that Night Train might have an idea on that too.
Well, it says here that there is even a companion CD available with the pre-typed formatted word processing files that can be opened, modified, and printed at your favorite word processor program. So maybe it doesn't include the CD. Maybe I forget the CD is extra, maybe. But in this old book, there was $49.95 for the CD.
Yeah, it sounds like it's probably separate.
Anyway, we got the CD. I forget whether it came with the book or you had to order it, but it'll probably say on the fly if it doesn't come with it. You can order it separate.
Yeah, exactly. That's what I was thinking once I get it. And if so, then heck, maybe I'll go ahead and pick that up too and help make it available.
Okay.
All right, CW, Christian, I appreciate your help very much. Appreciate your patience and the knowledge that you convey to us is invaluable. I just have to pay it forward pay you back by paying it forward to others.
Right.
So thank you, sir. I'll talk to you next time.
Okay, Dan. Next caller, you're unmuted.
Hi.
Hello?
Let's say hypothetically I stopped paying my home equity line of credit about 5 months ago. How would I use this process? Can you give me like a overview of how the bird's eye view of how it works?
Well, I wouldn't go stopping making my payments without knowing how to do it first. That's one thing.
Well, in this hypothetical situation, that has already happened.
Well, basically you're taking the debt title, which is the amounts that your payments are, the total obligation, and you're merging it with an equitable asset under a trust. And when you do that, that extinguishes the debt. So you're doing a withdrawal and a redeposit from the withdrawal from the general deposits you made originally, which was the debtor's credit contracts, and you're redepositing them as special in a trust. And you did the merger. And when they don't ledger you or give you the receipt that they've done that, then you get them for a breach of trust. So that's basically what NTT is. It's the extinguishment of debts and obligations through the merging of titles, the debt with the asset, under a trust.
Okay.
And it all, is spelled out in the beginning when we revealed NTT, which was November 7th of 2009. And we've got the top 20 audios that goes over the big bingos, but it's from 2009 of November 7th and forward on all the audios that explains it all. And it's all enforced in a court of equity. So if you're coming in here now and listen to what we're talking to, you've got a lot of foundation that you're missing because we're talking about trust, and we've gone over first thing was, how to form a trust, and now we're on the enforcement of the trust, what we're talking about now. So what you're missing is how to form the trust and all about the trust.
Right, and I have a little bit of understanding of trust on the private side. I don't know how statutory trusts work, but I'm not really interested in that.
I guarantee you what you think is private trust is nothing more than statutory. Because that's why I see right now the biggest difference of stumbling block of everybody that I see is they do not understand public versus private. That's the biggest stumbling block.
Well, what I mean by private trust is a trust that doesn't reference any statute. It's a contract set up between the settler and the trustee on behalf of the beneficiary.
Well, it's involving a contract. That's a public trust.
Well, is not a trust indenture a contract?
Nope. It can be. Contract is something different. The contract's under common law. Private trust is not under common law. Private trust is not formed by a common law contract. Right, what everybody's been taught.
So are you saying that under common law everything's public?
Yes, because today there is no money. Everything has been codified in common law. It's all statutes and codes. They've done a good job codifying everything. And when they do that, they change a law or a right into a granted privilege. But a private trust is not formed by a contract. It's an arrangement between the parties, forming a relationship.
Right.
An arrangement is not a contract. An arrangement's under equity. And equity is outside common law. It's not in that jurisdiction, that venue.
Can you explain the difference between an arrangement and a contract?
Contract is under common law. An arrangement is under equity.
So there could be no difference in the wording. It's just what it's called on the heading.
It has to do with jurisdiction.
I'm having a hard time understanding.
I know. It takes a while. Because we think all these venues are all one. They're not.
Well, I know that venues aren't all one, but
codes, common law is not the same as equity. You know, equity. Well, let's put it. Common law can't reach into equity, but equity can reach into common law.
Well, common law is not the same as at law either, right?
At law or statutes and codes. Again, statutes and codes or ad law can't reach into equity, but equity can reach into ad law or statutes and codes. So what happened in 3, everything was put into trust. You know, equity was put into trust, common law was put into trust, republic was put into trust. So in effect, there was segregation. One side versus the other side, and the two don't commingle, don't ever reach. They don't ever cross. Now you got public and private. And that's the way we always should look at it. Everything is always segregated. But the problem with the common law was that we lost the ability to pay because common law requires damages, and damages paid with lawful money. We don't have lawful money. So if we can't pay damages by lawful money, then we've got no common law. So in effect, they've froze the common law by putting it into a separate segregation. So not only that, what we have to watch out for is they've codified a lot of the stuff and crossed the codification and made statutes and codes which are lookalikes to common law. And they've done that to some of the equity also, because if you take like the maxim that you have on the statutory side, you have doctrine of unclean hands, which is the statutory lookalike for the real equitable maxim, say, plaintiff does not have clean hands. So that's a pure equitable private maxim. Plaintiff does not have clean hands, but they codified that, and when they did that, they changed it into a statute and code, and on the statute and code side, it's called doctrine of unclean hands.
But what I understand about statute or at law is it's all based on form, whereas common law and equity are both based on substance. Right?
Now, there is some discrepancy on common law where it has substance in it. The only substantive rights enforcement of the real man and woman is in equity, not in common law. Read the first beginning sections in Gibson's. I'd say what it's like the first. What's some of those section numbers? The harshness of common law and all those. 1 through 9.
Yeah, I have started reading some of those. It talks about how equity basically fix the deficiencies of common law.
Ate the heart out of the deficiencies of common law.
Okay. I've been listening to old recordings, and over and over again, NOI and SOI are referenced. Can you tell me what those stand for?
NOIs, those are notice of interest, and SOI, statement of interest. The NOI is the claim, and the SOI is the evidence to back the claim up or the material fact. NOI is like, you broke my arm, and the SOI would be, here's my x-rays and an affidavit of the witness. So you've got to have an NOI with an SOI, or else you can't prove the fact. Have just an NOI without an SOI, then the NOI times out because it's just a frivolous claim.
Okay.
Yeah. Do you have any questions pertaining to the topic we went over tonight? Because what you're asking is a lot of basic questions, which I've gone over thousands of times already, and I really don't care to get into them. What you should do is go back to the old past audios and listen from 11/7/2007 and forward.
All right. Is the top 20 available for download?
Yes. We do the top 20 audios repeats on also Tuesday night.
Because if they're in download, I find it a whole lot easier to listen, pause it, take notes, all that stuff.
When you join the group, are you in the group, the NTT chat group?
I have tried to get a hold of Faith to Trust, and lately I've been unable to do so.
Well, I'll tell you probably why. It's because you got some kind of attitude problem. Either that or you won't accept my agreement.
Well, I didn't accept the agreement because
then you will never get in.
What's that?
You will never get in. I will never grant you access to my audios.
Well, I didn't accept it right away because I didn't understand it.
Okay, well, that doesn't change the fact. Now, you will not get in until you agree.
Right, and I agreed to it now.
Okay, well,
can't get a hold of her.
She'll give you access to the audios. And don't tell me you can't get a hold of her.
All right.
Anything
Thank you very much. No, I appreciate your help, though. All
right, thanks for coming on.
Good evening, Christian.
Hey, who's this?
This is Strawman.
Hey, Strawman.
I think that the difference between the arrangement and the contract has to do a lot with intent and with nomenclature, and of course, what jurisdiction you're living in, where you reside.
That's the big part. It's the relationship or the jurisdiction of the relationship that you claim.
The other thing is that you mentioned, and I've heard you mention it before, that we need people who know the litigation side. And then almost in the same breath, you bring up Dr. Graves. And I know that he's on that same coast. And I was wondering if you do a seminar, or let me rephrase that, when you do a seminar, if that would be helpful, if he would be interested so that he can pitch his course, to have him do a training session with the people who come to sharpen their litigation skills.
Yeah, he might be interested, although I don't think he, is into what we do with the trust end of NTT. But
oh, absolutely, right. But the court rules have been merged, and he would certainly be in keeping with his style of approach to teach just the rules and just how to access and litigate.
Yeah, he could probably give you a litigation skill scenario or education on the at-law side, but as far as equity, I'm not sure whether or not he understands equity at all.
Right. So what you're looking for then is someone who understands what Dr. Graves understands about rules, but also
we've had numerous people that I had high hopes for because, number one, they were paralegals. Number two, they were in this type of field and wanted to do something with it. They were interested in NTT, to be specific, in its application, but found out that they were here just for the loaves and fishes and not the doctrine or the sermon.
Well, I think, I don't know if I've proven that I'm here for the sermon, but would it be helpful if I took some courses to become a paralegal so that we would, have that skills on that side?
Well, I think we could probably find somebody who had litigation skills that was, say, a paralegal already, that had familiarity with the at-law side to begin with, say both in state and both in federal, or, one or the other. Because we've got a lot of people that don't know how to operate, say, in federal. State's a lot easier, less stringent, but in federal, you got to have all your I's dotted, your T's crossed, and everything's got to be exact. It's much more highly specific. And most people don't know any litigation skills at all. And how are they going to go into court?
They won't even get through the door.
Yeah, because they're not filing their counterclaims right.
Well, I had a hypothetical situation where I was filing SOIs in 2 different states on the same day. And in one state, the clerk, they passed it up to their boss, and the boss came out and said, "I'm calling the FBI. You can't do this. I'm writing a letter." And I said, "Fantastic. That's great. I want you to explain to me why I can't file a notice of a nomenclature change." That's great. And then that was Georgia, hypothetically. Florida, same type of document. I've recorded them before. And she said, "Oh, we can't record these." I thought that was odd. And she went and checked with her supervisor, and they recorded it. So I'm wondering if there's something going on at the clerk level in the courts where they're being told to look for certain types of documents and give them extra scrutiny. But still, aren't they practicing law to not record something?
Well, I know on the county level, if it's an affidavit form or a notice form, and has to do with real estate, they have to record it.
Well, I think that's the concern, is they can't see that it has to do with real estate because it doesn't necessarily state that.
Right. Although you could put that in there saying that this is a real estate matter in the notice.
Okay, without saying that it's a particular property or anything like that.
Right. In fact, if it did contain a piece of property, you could put the property description in there, I'd say.
Well, the property description doesn't really relate to the equity interest. We're dealing with titles, not necessarily property. So I don't.
Right.
Is that appropriate to do that?
Well, equity looks at property being your rights. At law looks at property being just a legal piece of paper, a title.
Okay. So we're dealing with the rights to the property.
Yeah. Right.
Okay, that simplifies that. I think that will fly through both of those clerks now. And I think that it's great that we know ahead of time, a week ahead of time, what the next, actually the last maxim will be. But it is, I think, frustrating for you not to have the call flow from the reading for an hour to an hour and a half on a maxim or a grouping of maxims, and then flow right into a discussion on that topic. So I'm wondering if there's a way to...
Yes, because most everybody is like into... They want a fix for their problem, and they're not here for the sermon. They're looking for the quick fix.
Well,
they want the loaves and fishes.
We have two sides of that problem. Now, we have the people who it's their first time being exposed to this, and they want to know what an SOI is.
Right.
And then we also have the people who are saying, well, I have this idea about the root trust, and they're kind of ahead of the curve as well. So it would be nice if we could work on the topic of the day, and maybe I'm thinking that if there was a way to build that up during the week, because I know that the Welcome chat group really is far-ranging, and it seems to tend to deal with everything all at once, and it can be a little bit hard to navigate in there. So I'm wondering if there was a way to the way that they would push a movie, as they would, give you little teasers, and then they would build it up, and then you'd have...
well, the problem is we don't have like a basic one-on-one course going simultaneously with the more graduate level stuff that we're on here now presently.
I agree. That is an issue.
Because everybody sitting here talking with us or listening might be totally lost. Probably are. Because we're not even talking, say, NTT. We're talking about equity. And how does that relate to NTT? And what is NTT? Well, for the last 3 months, you would probably never found out what NT really is. The only way you're going to is to go back and listen to those beginning audios.
Which are being replayed every night.
You're right. And I've gone over the same basic stuff, how
I
you
believe.
Read it.
No, I know. I'm kind of tired of typing it every week, too.
So, not to be mean or facetious, it's like, hey, I don't want to repeat something that I've gone over 10,000 times already. Go back and listen to the basic audios. And then when you get up to speed, then come on this call, and you'll understand what we're talking about then.
So, just because everyone has their own, and we'll call them little cases that they're struggling with and trying to figure out the details of and working out their local rules and their county and state approaches, is there something on the horizon that people can say, okay, January at this location, I'm going to order my flights and I'm going to get a hotel room and I'm going to be so prepared because I've got 6 months to buckle down and listen to everything and read everything, and I'll be ready to speak at the highest levels with Christian and whoever else is there.
Yeah, they got 5 more months to get prepared for that. So that's what's coming up.
So there's a tentative time frame.
Yeah, after the first of the year. Yep.
Oh, fabulous. Now, I'm not complaining, but I have heard after the first of the year on the recordings for multiple firsts of the years. So how can we help to get this one to come to fruition?
Now, let me explain why, because usually when I thought we were 3 steps ahead, and then when I give it find out that actually we're like a half a step ahead. And then I was basing on what we're going to do, but thinking that we have gone ahead 3 steps, and here, no, we haven't, so we got to go back to basics. So, yeah. So that's what we have to do.
So to me, the big issues seem to be litigation and just knowing and following the rules, enforcement, and probably...
Yeah, this is the only place that I know of that is teaching you from A to Z and is not giving you some piece of incomplete information because we haven't finished step Z. And that's what we're doing right now. I am not releasing one piece of information on writing of any kind of documents until I know that we have the step Z completed. And the step Z is that we have enforcement. Everybody gives a piece of paper right off the bat of some new discovery, some new thing, and they don't teach you how to take it to completion or enforce it. And what do you have? Nothing.
You have wheels that are spinning. But
yes.
The third item or the third area that I think is critically important, and I don't think that people who have no idea of litigation or no idea of how to build a bill should be attempting going after the root trust, but I think that there's going to be some need to kind of segregate people according to their abilities. I'm not saying testing necessarily, but by talking to people what they're comprehending. I just hate to see people get in over their heads even at a seminar situation and kind of
right.
get their minds blown.
Yeah. I don't know how to.
Well, I think that the idea of having a curriculum that is taking care of the foundational aspects of it so that it's not being done on these calls is appropriate.
People have to understand we are working on curriculum and things, but we don't have the manpower. We don't have the volunteers. We've got a few people, you included, Carl, that are volunteering their time to develop stuff. But we don't have hundreds of people behind us willing to do things that we need to have done.
There's hundreds that are signed in.
Yes, doing nothing. Not even doing the homework.
Waiting for the magic form.
Yes. And we haven't been around for 30 years. So consequently, we don't have the curriculum developed. We're still in the beginning stages here, getting things solidified. And just because we don't have documents doesn't mean that the doctrine or the principles are not correct. It's just that you're thinking out there with debtor-creditor land stuff that people have been doing for 30-plus years, and they got all these documents and curriculum compiled for 30 years worth of work, and they got all these masses of people helping, and we're just trying to get this little plane off the ground here, an NTT, and get it all working. So cut us some slack.
Oh, I'm not complaining. I'm working as hard as I can. I'm saying that there are documents.
Yeah, because I know the work you contributed, so yeah.
There are documents floating around. There are people who've developed things and are trying things, and in the same way that you're not releasing documents, it's hard for us to share documents knowing that, there are people out there trolling for magic forms, and we're reluctant to put our meager attempts out into the public.
Yeah, and then they're charging $6,000 for it.
Right. But that's all. I just want to get that off my chest. I'm not complaining. I'm very appreciative.
Yeah, well, after the first year, we plan on putting together one of our first seminars, so we're doing a live seminar.
Well, I'm looking forward to meeting everyone and shaking some hands.
And we had opportunities before to bring up workshops, but for one reason or another, they just didn't plan out, And this last time, it's those that stepped forward on the workshops just fell down on it. So.
Well, I've organized workshops and seminars in the past, so I'd be happy to be on that committee or head that committee if you don't have anyone else.
These are all growing pains, that's all. Just all I got to say is, people, be patient. Patience is a virtue. We're running as fast as we can.
Oh, no. All right. Well, I'll let you talk to someone else if you got a queue line lined up.
No, you got any more questions? Anything else?
Most of my stuff is all pretty mundane right now. I'm working on a lot of the stuff that I've learned over the last 8 months or so. Actually, coming up on a year now. And I guess the biggest problem that I have is
out there. Can you give like a
I'll tell you what. The first week I said, "Oh, I am going to master this in 3 weeks. I'll be the top of the game." And 3 weeks into it, I went, "Oh my God, this is huge!" And 6 months later, I was learning things every day, every hour, and 6 months, 8 months, 9 months, every day I'm overwhelmed and amazed at what I'm learning. And I think that anyone who doesn't have the luxury of spending all day, every day on this doesn't appreciate how amazing this is, because you don't get it into your pores. I dream this stuff now. I wake up in court. I wake up talking to clerks. It's amazing.
How long did it take you to get an understanding of, say, NTT or a grasp on it?
Well, that's a good question. I think I probably got a pretty good grasp of it in about 3 months, but that has to do with the fact that I was transcribing calls, and then there was an equity group that we did on Gibson building a bill, and I learned a lot from that group. I think that spending as many hours a day as I do on it, I think it's a different learning curve. But if you have to be at your job all day and then come home and deal with the family, and then you got a couple hours, and that's a coaching call, it's going to take a long time.
So you were spending, say, 3 months night and day.
Night and day.
That ties in just about with everybody that I talk to. 3 to 4 months of studying pretty much nonstop. And in that 4 months, you get about 1,250 hours, and that's what I find about it, what it takes. About 1,250 hours of study.
Yeah.
And it finally starts unwinding your DC mind, and you can absorb you got room in your mind to absorb this other NTT and equity. And it's about 1,250 hours.
One of the interesting phenomena that I've witnessed is that I've become not aloof, but I feel distant from what I thought was very important at this time last year, and what other people are going through. I can't relate to it as well because it's no longer on my screen. I see it. I know that people are suffering with foreclosures, but I already have a different approach to it in my heart, and I can't talk to them about it, but then all I can do is be empathetic.
Yeah.
It's a very it's an uncomfortable place to be sometimes.
Well, what we're creating is more, like I said, a beneficial rights movement concerning.
And that's what I thought. I talk about that instead of specifics about what we're doing. We talk about where we need to go as a nation. And that was another question I had for you, is once you've adapted your root trust and you've claimed it and withdrawn it and redeposited and taken control, is there a way at that point to participate in public policy other than, because I don't see myself voting at that point, is there a way to participate other than just like contributing to politicians?
No, I don't think so. Politics is at law, and I couldn't contribute to the at law side.
So how would you participate in public policy?
We'd have to get around public policy because the republic is not based on public policy.
It's not right now, but I guess that's my question, is how do we change it?
Well, it's like getting the republic back, merging the titles and bringing the republic back as being the perfect title. That would be the ultimate goal, I would say. And that's not public policy.
Oh, okay. Okay, so that would be done with a new Declaration of Independence?
Yes, it would be a country of we the people, again, based on individuals, instead of this segregated two realms of public versus private. And only many have been tricked into living in the public realm and not in the private at all.
But what I'm seeing is maybe a second, deeper recession that I would say is a depression with a little bit of attempting to hide from that fact, like you were talking about in the trying to avoid your responsibility to show up in court, let's say, even once you've been subpoenaed. There are people out here who, we don't have 14 million people in a starvation camp like they do in North Africa, but we have 24 million people who are right on the edge of that.
Right.
Who haven't worked for a year or 2 or 5. And there are people getting desperate out there, and public policy isn't fixing that.
No,
in fact, it's making it worse.
Public policy does not work because public policy is based on commerce. Commerce,
right, but I've heard you say that on other calls, though, Christian, is that we aren't participating in public policy. So I thought that was part of your kind of mandate to us to become more involved and not just withdraw into what I call as my cell, where I just work all day, every day.
No, I keep saying that we should learn how to do government. We need to learn how to do government. Doing government is not public policy. We've got a wrong economy. The economy of public policy is based on commerce. That is our God there. We worship commerce. Everything under public policy is done for the improvement or the contribution to commerce, to speed commerce up. It's all about economics, public policy. No, that does not have the right economy. God's economy does not include commerce.
It includes paying it forward.
Yes. There was no commercial economy before Adam fell.
That's a big breakthrough for me tonight. I appreciate that, Christian.
It's learning to be Lord over your estates, both being equitable and legal, until we merge them, let's put it that way. And not to be Lord over other people, but Lord over your own land. And be an imitator of God. Ephesians 5:1. And his economy is based on giving, which is Philippians 4. It's to the account of your giving that you will receive. There's no mention about money in there. We don't need money. We don't have to have a commercial economy. And believe me, with or without me, that's going to happen because Christ is going to come back and establish His kingdom, and His kingdom does not depend upon commerce. He threw the money changers out of the temple Not because they were cheating people. No, because they were doing commerce in his house, in his father's house. And that's going to happen, with or without me.
Well, it'll be a great day.
I can apply the maxim, what ought to be done has already been done. It's already done. It's tetelestai. It's finished. God looks at it, everything is done already. He's already paid the price. Now he's created the titles, and now the second time he comes, he's going to merge them, and he's going to establish his kingdom. I don't have to worry about that. It's already done. Yeah, we don't have to learn how to do public policy. We just have to learn how to do government. How this country was formed when it first was formed.
Of, by, and for the people.
Yes, yes.
Well, thank you. And I wish you the best.
Hey, Carl, thanks. Appreciate it. Thanks for coming on.
Hello, Christian.
Hey, who's this?
This is Doyle from Arkansas.
Hi, Carl. How you been?
Well, we've been busy. We had our hearing Monday.
How it turned out? What was the hearing?
Well, it was the hearing we had requested a hearing to bring in have a declaration of trust.
Prove the validity of trust?
And as per usual, it was all denied. And the judge said it was a 12B ruling, 12B6 ruling.
12B6, huh?
Failure to state a claim.
So what's the next step?
Well, we were discussing whether we should try to do a appeal or just drop it and wait till the troops are better rested and learn a little more about litigation. It is apparent that we're not crossing all of our T's and dotting all of our I's when we're dealing with these guys.
Yeah, and federal is highly specific.
Yeah. We went into that hearing, or I felt like that was going to be what we would get as a rejection or denial of our wishes or demands. And
anything strange said that gives you indications of anything?
Well, the judge said that equity is only, and he gave an example of what equity is, and he says, somebody comes across your property and they trespass and they come and cut down all your trees and sell them. He says, then equity reaches in and takes the money from them and gives it to you. So he also said that appointing a trustee is a felony in the way that I did it, a felonious act to appoint somebody as trustee. And so he was adamant about me rescinding the public appointment as a trustee. So we're going to have to, I guess, submit a rescission of that appointment.
Yeah, he may be right on that because everybody wants to appoint somebody and force them, with trusteeship down their throat. No, like they have to accept the appointment and they have the right to disclaim.
Well, I mentioned to him that I had filed it filed the appointment, not appointment, but the trust in the party had ample time to send it all back and say he couldn't do it or didn't want to do it.
Mm-hmm.
And I told him, I said, that would have been fine by me. Then I would look for somebody else to be the trustee.
Right.
He didn't seem to think that was a very good answer. But I did tell him that I would rescind the public appointment, and that would be taken care of. So at this point, I'm not really sure if it's worth going any further with this and fighting with them in this particular battle, or just because I think that in light of the mistakes that we've already made and what we've done, and after having listened to you this evening, it seems to me that we've got too many holes in our boat to make it float through a appeal.
We were pressed into this. We didn't have we just started on the enforcement issue, and the things that we discovered along the way, weren't doing you much good because you're in too far already.
Yeah, I think we've already got this boat pretty well painted, and to go and change the color on it now would be we'd have to pull it out of the water, and it's just almost impossible and practical to do now.
Yeah, because I think when this all started, we weren't even quite sure. We were still back on the in-camera hearing thing under one court venue.
Yeah, he was looking at us cross-eyed whenever we were saying that.
Yeah. Now we understand it's two venues in one court and it's all in private equity.
We've learned a lot since we've been involved in this. Got some battle scars.
Well, I think you had a win, although maybe we didn't have a win-win. The party withdrew their claim, right?
Yeah, I withdrew the adverse claim that we had against the party that was claiming to be the trustee as a 13 trustee. And I withdrew that thinking that we probably didn't have all of our ducks in a row at that time, and in retrospect, that we weren't as advanced in our thinking as we are now, and so I think it probably would have been a good chance for them to have weaseled out of that at that time. And this was back in January, February. I think we learned a lot then. So.
Didn't they drop the claim though? You said they dropped the claim before against you on the tax.
The Arkansas Department of Finance was battling us severely at every turn. They were blocking or extending the bankruptcy and drawing it out, and Arkansas Department of Finance finally withdrew. So that allowed us to go into the buyback of the non-exempt assets, which we are now in a contract over a 3-year period to do that. So we're in the second month of that.
Seems like there was enough of equity or something that we were doing right on that part, because that party complained that they were no longer in the driver's seat.
Well, that would have been the Chapter 13 trustee. That was Mrs. Babin. And that was what was relayed to me by our attorneys that we had hired to supposedly get this thing done and over with. And in fact, I think what they did is they drug it out longer than would have put it just not hired any attorneys. But he told me when we had the meeting, he told me that she was used to being in control, and here you've come and put her in the back seat and you're behind the steering wheel, and she's livid over it.
Right.
So
perhaps we better analyze, what we were doing right in that sense.
Well, basically what we had done was just given her an appointment, and really what she had done is she had failed to send it back and say, hey, I don't want to be your trustee, I can't be your trustee. She kept all the documents and just repudiated by filing an adverse claim. Retrospectively speaking, I think we probably should have gone ahead and prosecuted that, because we subpoenaed her to come and testify in the court as a real person rather than a fiction, and we might have learned a lot more had we gone through that. I wish now we had have not have dismissed that.
Mm-hmm.
But we had those attorneys, and I felt that we couldn't do what we were wanting to do with those attorneys.
But you didn't start out with the attorneys. Yeah.
No, we didn't start out with the attorneys.
Right.
So it's just a big mess. We, due to lack of knowledge, we've kind of just, instead of painting the boat one color, we striped it up all over. So we got a mess. It's a camouflage boat, I guess.
Through everybody's mistakes, we'll build on it and go farther yet, so.
Well, we certainly are the kings of mistakes. I'm going to change my name to Mr. Mistake, and then everybody will know me then. But we had some questions in regard to the jump, as far as does that require any litigation?
Jump.
Okay.
In the jump in what respect? I mean,
well, jumping from the public into the private.
Okay.
And we were, that was something that we wanted to discuss, as far as, is there any litigation that's going to be necessary?
Well, I don't think there's any litigation necessary, only when the trustee doesn't do the job and he creates the breach, and you got to enforce the breach. So if the trustee would do the job, there'd be no necessity for going into court. But, I don't expect that to happen.
Well, repudiation seems to be their middle name.
Absolutely.
They're attorneys.
They don't know that they are the servants of we the people. And until that time comes, I think we're going to have that problem.
So are you saying that to make the jump, it's probably going to be probable that you may have to do litigation?
Yeah. Yeah.
Well, we've got plenty of practice at that, so bring it on, I guess. We may not do it right, but...
I mean, the way I've seen it so far, you could do, the withdrawal and the redeposit, and you've done it. Equity looks like it's done. It's completed. But the at-law side just won't recognize it. They won't give you a recognition. They won't give you a receipt.
Well, if they don't give you a receipt or recognize it, then, that's the problem I had with the bankruptcy court is, I asked for a special hearing, come in as a special appearance under a special deposit to have a declaratory decree for the establishment of a trust. And he didn't even hardly talk about any of the trust documents. He just basically skipped over all of that and just said, well, this is 12b6 ruling, and I'm going to rule that you don't have any claim to get relief for it. So it seems to me that they're quite capable of just slipping through the tiny cracks.
That's where the appeal or they didn't, then that's where the court stuff comes in. That's how we're going to get it enforced, because we're going to have to have the skills, and we just don't have the skills just yet. So.
Well, I'm wondering, would it be futile for me to even try to appeal this judge's decision as to the fact that we filed a equitable claim requesting a recognition of a trust, although we may have not gotten it all correct and everything, is it possible that we can still take that to an appeal and get somewhere with it, or you think it's...
At a properly pled equity pleading, I'd say yes.
Well, I don't know how properly pled it was. He seemed to ignore it, and he laughed at all those equity maximums that we put in. He said, I read all those maximums, but those don't mean anything to me. And he said equity is whenever somebody comes across your property and they cut all your trees, then you can go into equity and get the money out of them, get relief.
Mm-hmm.
So I could tell that he had a very distorted definition of what equity means. And he may not know what equity means.
Quite possibly, yeah.
Well, my question to you then, would you recommend my trying to appeal this to appellate level and see if we can get a 3-judge panel to
If I was confident that I had an equitable pleading according to how Gibson's has laid out, I would go for the appeal.
Okay, well, I'm going to look at it and see if I've got all the elements correct. And then, I think we have, 10 days, or how many days do we have to put a notice of appeal in?
I believe it's 10 days.
Okay. So we don't have a whole lot of time, and then we need to, I don't know, I'm not really sure what I would need to do to do an appeal. I guess we can look that up in Gibson's as far as
the notice, that notice is probably easy, but, the appeal itself,
the documents for the appeal.
Yeah, it's like putting a term paper together,
Yeah. It seems to me that we have failed at the midterms, and so the term paper might be more difficult to put together than one might casually observe.
Yeah, but it all starts with the foundation. The foundation is the elements there necessary to prove that you had a trust. And if you had a trust to begin with and had it pled in the paper and that judge didn't recognize it, then he's obviously in the wrong.
Well, then I would think that we have a good chance of taking it to the appellate level and probably winning then, because we had all the elements of trust. And then we had the bill in equity to bring it into a special court of equity with a special appearance, a special deposit, or under a special deposit. So we might have a possible win if we take it to the appellate level.
I think that the upstairs people, they're the ones that are giving all these, decisions back with all the equity maxims in them.
Well, I thought it was rather strange that this judge sitting there, now the other judge that I had recused himself, and so he wasn't there. This was another judge, and he made fun of the equity maxims that we had in our pleading. I thought it was very unprofessional, the remarks that he made.
Well, it sounds like he was coming from the at-law side, which they can do just about anything they want there for that.
Well, if we were to take that to the appellate level, and were to win, would that not look kind of
bad for him?
Bad for him?
Yeah.
Well, I don't know how much of what he was saying was being recorded, because he was saying some pretty obnoxious, derogatory statements about equity and what we were trying to do.
We're going to have a higher skill level to go in and enforce this.
Well, apparently that's something that we're all going to need to learn to do, is to do the litigation.
And it may not be as hard as what we're trying, It may be that we're just doing something, basically we're, doing something wrong. And it could be a lot simpler. Who knows? before we were looking before, how do we invoke the court of equity? We were looking for some specific magic words that you had to have this in there and that in there and this and then it had to be just this way, how do we invoke this court of equity? Here it's just as simple as if you've got a trust, that is cognizable in a court of equity because it's one of its children. It's automatically in. So it comes back down to the basics in the trust. Do you have intent? Do you have purpose? Do you have parties? Do you have specific trust strategy? You got a method of formation. If you got that in there, you got equity.
He wasn't interested in talking about the 5 elements. In fact, he didn't even really want to talk about the trust at all.
Uh-huh. Wonder why.
Well, it's probably if he were to go to that point, then he would have to recognize it or do something to recognize it. And I don't think he wanted to do that. I think his total objective was to get us out of there. And
because what to say, okay, let's just close this down and see what they do afterwards, because they might not come in and do any appeal, and then if they don't, well, we won. We got them.
Well, he indicated that he was very perturbed at me for, messing up their sandbox. And, they had drawn the picture of how they wanted it all to work out. And here I come in and fluffed it all up with all this stuff. And he was not great.
You did, yeah.
He spent a little more time talking about that than he did, talking about our actual pleading. The only thing that I think that he really took note of in the entire pleading was the equitable maxims, and he was making fun of it, that I would put such ludicrous statements in a pleading like that.
Which made an example for anybody else that would be copying you that, hey, we don't want to do that because that's what's going to happen, but that's the direction we want to go.
Well, we had
if all these opinions out of the superior courts, out of the Supreme Courts, are coming out with maxims in there, even today, and he says that these maxims aren't anything?
Well, that's what struck me as being very odd. Why would this is a federal judge on a bankruptcy bench, make such snide remarks about my putting in equitable maxims in my pleading, pleading a bill in equity for a trust, and then he would make these comments that were such rude comments about my using the equitable maxims. And I thought, well, this guy either is really, really stupid or he's trying to pull off something.
Yeah.
I'm of the opinion right now, after having been in front of several of these judges, that they don't have a clue. They've got only one thing on their mind, and it's totally at law, and anything outside of that, they don't understand it, they don't see it, it doesn't exist.
Right.
They act as if that's the way it is. And it seems to me that that's the case. They're totally oblivious to what we're doing or what we're trying to do, because they don't understand it, they've never seen it, and so if they don't understand it and they've never seen it, it does not exist.
Right. So we have to educate them by taking it to an appeal and teach them a lesson that it does, because out of the appellate courts comes the equitable maxims.
Well, I was...
Nightingale put together research. He's got 200 cases that he's done research on of all the maxims that they tout out of the higher courts. And that's just scratching the surface.
They can't be that many. What, there's only like 19 or 20 maxims?
Yeah. But they use the same ones over and over and over again.
Maybe they're trying to tell everybody something.
Yeah, the maxims are alive and well and running the whole show. Maybe they don't want you to know that.
Well, maybe that's what that judge was trying to do, is trying to throw us off the trail.
Probably his job at law to do that, yeah.
Well, could it be possible? Could it be possible that that's their job to throw everything out or dismiss all that kind of stuff whenever there's something brought in that's claiming equity, and then that forces you, if you want to really get equity, is to go to the appellate level and then go above them? You think maybe that's their modus operandi?
That's the only thing they can do.
Maybe they want to see just how serious I am about this.
Right.
Well, we're still hammering away at it. I was contemplating doing an appeal. The sheer complexity of it almost makes me want to run and hide. But maybe we can pull it off.
Up to you, but, I would say if it was me, this would be my Jericho.
Go around the walls shouting, huh? We want trust. We want equity.
Because the only way that the real man is going to get his rights supported is in equity. If we can't get an enforcement out of equity, there ain't no man or woman alive that's got any rights anymore. That's the kind of battle we're in. Either we're battling for our freedom or we're battling to be slaves. One of the two.
I prefer to battle to be free than to be a slave. To be a slave, you don't have to do anything.
Follow instructions, yep. When they say jump, you ask how high.
Yep.
I think Patrick Henry said it the best. Give me liberty or give me death. And that's just exactly where we are, right on the grounds of Common there.
Come back to a full circle.
Yes, yes.
Well, it's because the people have become complacent, and they've allowed the government to provide all of the education for the children, and everything's real easy. Just, we're here from the government. We're here to help you. I got a notice back from, you remember I mentioned to you that I had merged title on the property for the farm?
Uh-huh.
And I sent a notice of that having been done to the land commissioner of lands, as well as other people. And he sent me a note back and said, well, you owe $693 and you got to pay this, and then we'll redeem your property for you. I thought, well, that's a strange notice or a return. And it appears to me that he's trying to recontract with me.
Apparently so. Trying to get you to acknowledge the debt again.
So I'm thinking perhaps I should just merge the title on that and submit that to the county or submit it back to him.
Didn't you say you did that already?
I have not done that yet. I've not done anything with that yet. I'm trying to decide what to do. As far as I'm concerned, it has been done, and there's no trust, nor is there any bill due, because if there was any bill due, it would have been extinguished by the equitable title.
Then you did do a merger before.
Yes.
Okay, then I wouldn't keep on acknowledging the debt. I'd keep sending him bills that I have paid it, and through the extinguishment and the merger, because he's going to keep on repudiating.
Well, you think then that it may be necessary for me to litigate with this individual?
I might have to, yeah, because if they won't give you, if he keeps on repudiating when you've done the merger, then it comes down to the enforcement. The enforcement is inequity.
Well, I'll need to write him a letter and remind him the error of his ways.
Yeah, I refused your repudiation. He's the trustee. Do the duty. It's already been merged here with stuff. You're supposed to ledger it, If you don't ledger it, it's going to be a breach.
That's the problem that we're running into is we have people who think they're the kings and the slaves are not supposed to be out there doing what we're doing.
Well, we can take back the courts through equity and get our rights enforced, but we're going to have to go into the courts and do it.
It's kind of a catch-22 there. You got to go in there and you need to know how to operate in court to do that.
But we're learning. We're learning.
I had a question that I didn't ask you when I was speaking to you privately, and I don't know, it might not be, and you don't have to answer it if you don't want to, but I wanted to ask you, since 422, how has your life changed? 22 of 2011.
Well, for one thing, I've kind of taken a throttled back a little bit and taken and enjoyed life a little more.
So you're able to...
like I've made it, so. I mean, I cracked the code, and I'm sitting there enjoying the coconut meat now. So the coconut's been cracked. The code's been cracked. I am now operating in power and with force.
Donnie wants to know, how does that affect your daily life?
I don't think much has changed, really. I still do the same thing I do. I still read a lot.
Well, do you still pay the water bill, or do you have an arrangement that deals with all these daily or monthly grinds that you have to go through?
Well, I can't tell you that because it's private. If I did, I would breach my trust.
That's what I wanted to hear. I understand.
Anything else?
Haven't gotten anything else. There's always next week. But I just wanted to kind of fill you in on what we'd learned at the bankruptcy court.
Mm-hmm.
Apparently, whenever you appoint someone trustee, there's quite a bit of an obligation in a federal case. The judge was very adamant about getting that released. So,
yeah, I don't suggest that anybody would put the judge as a trustee because, number one, he can't hear your case. You really need the judge on your side so that, excuse me, so that, he can rule favorably on your, instead of going against you.
Mm-hmm.
I would think it would have been a prosecutor or somebody on the opposite side that I would have made the trustee on and let the judge be neutral.
Well, the thing about the bankruptcy case is sometimes there's more than one attorney and they all get up there and they're representing somebody or something somewhere or somehow, and it's kind of very difficult. I've noticed it's difficult to nail down exactly who is the party of interest, and who you hang the badge on. Now we have a
trustee that is publicly appointed. I would make him privately my trustee also.
Well, going back to that, should I change the appointment of trustee instead of having the judge trustee, just have him to send back all of the documents and reappoint the Chapter 7 trustee, the trustee?
Well,
and
then talk about it being an appointment of trusteeship. It's like you want to come up with a different term.
Well, it's
an offer for the office of trustee, and really they have to accept it, so they got the right to disclaim. But I don't think many of them are going to do that because they can't do it properly. So if they sit there and say, I'm not trustee and hold trust res property, then they are acting as trustee, and the law says that they are trustee then. So
I pointed out to the judge, I told him according to the CJS and the law of trust and CJS 90, I think I quoted, that if the trustee does not return the trust documents and does not say he can't be the trustee or whatever, then the law says that if he's holding the trust res, then he's acting as a trustee, whether he's doing anything or not.
Yeah, if you told him that, then he knows.
Yeah, exactly what I told him, and he kind of batted his eyes and he went to something else.
Yeah. Forget about his felony thing.
No, Donnie said that he said I was misguided in my readings.
Okay.
Well, in this appeal, should we just leave the trustee as is or appoint the Chapter 7 trustee? I'm thinking that probably it would be just as well to just leave the trustee as it is.
And that is who? Now the judge?
Yeah, the judge. Now he's holding the trust documents.
Yeah, I don't know about the judge pointing him on that, but you have to appoint somebody else now. So, plus you told him that you're going to rescind it, right?
Well, I told him I was going to rescind the public. There's a public notice that was filed that appointed the judge of being appointed, and that was what they were wanting me to rescind. And I told that judge that I would do that. Now, I don't know if the other judge is going to send back all the private documents. I haven't received anything, nor have I received the order. Normally they send those out like the next day.
Mm-hmm. Well, it wouldn't make any difference. If the trust is vested, if he sent it back later on, that doesn't make him not trustee. If he's gone past the vesting point, the trust vests, then he could send back the documents and it still doesn't make any difference. He's still trustee.
Well, my thought is it would be better if they would do the duty as a trustee in the private realm, because nobody is liable, and basically all they have to do is just extinguish all of the liability, and there is no liability after it's been extinguished. Is that correct? Maybe I'm missing something here.
Right.
It seems to me that it would be a lot easier, far easier to do it that way and quicker and cleaner, just that they wouldn't be collecting all of that money that they've collected through those background bonds. They would have to give all that up. And he may not be wanting to do that, and or it may not be very expedient to do so, because those bonds are probably sold off to somewhere on the other side of the world, and they've got to try to get them all gathered back up.
Mm-hmm. You go after those bonds.
Oh, a judge also said that the public notice appointment was the same as a lien.
Well, I don't understand how that could be a lien.
Well,
not a debtor-creditor filing for a debtor-creditor lien. It's just a notice of trust.
Notice of appointment. Well, I think what it is there's such a large amount. And you remember when I visited with you last time, the judge was really complaining about all the problems that it was going to cause him. And I think what it is those background bonds are very, very, very large. And he was going to have to pay the taxes on those.
Well,
and he was not very. I think he was probably having to take medication for ulcers or something because he was really complaining about that. So that kind of indicates to me that those bonds are very large.
They always are. That's what's running everything.
Well, I guess we can probe around the edges and continue finding out. Now, we're learning more and more as we do this stuff. We're learning that, those background bonds are there and they are large. At least we've demonstrated it in this situation.
Right.
Is there a way that one could find out the value of those through FOIA or the amount that those bonds are?
Find out what the QSIP number was that they run them through, yeah.
Well, that would probably require some...
Any broker with the right number could track it.
Would you not be able to track it with that case number that they have because it's got a case number?
Well, that case number's probably been changed to some QSIP number that corresponds with it, and unless you knew that, then it probably wouldn't pop up. But
yeah,
like they resurvey it, give it a new title, and then that way you don't know that it's connected unless there's some way of finding out what that number comports to.
Probably need somebody that's on the inside that knows how they do that.
Yeah, had an accountant in the courthouse, so they're the ones that know that.
Could you file a FOIA request with that accountant at the federal courthouse and say, hey, I want this information specifically for this case?
Possibly. Either that or you could file a case
discovery request.
Yeah, for discovery, and you do a receivership or so, the tracing, and have the master trace the funds down.
Well, I think we're probably past that at this stage in this game as far as doing any discovery.
Yeah, on this case, yeah, probably so.
Well, maybe what we've done blazes the way for other people who are maybe just getting started in a bankruptcy or something. Some of these things that they need to be aware of and look at as they're going through these.
Right.
I don't know how many people are going through this.
Because we've got other cases going on, and people are just making the basic fundamental mistakes of litigating in the court. And I think that's what's hammering them.
Yeah. It's called not having the knowledge. Lack of knowledge is pretty rough, brutal.
Trial and error before we find out whether we got it right. Fundamental principles and things are there. And plus, we're fighting an enemy that might morph as it goes along. So, and if they don't want you to go in there, then.
Well, that was what I took away from this hearing that we had on Monday, is that they don't want to go there, and they certainly didn't want us to go there. And
right now, well, I think the enforcement comes not just at the lower level. If necessary, the enforcement has to go all the way to the upper level courts.
Well, I have seen very few cases where the lower level, the first level court, made a equitable ruling. And so it may be that you have to go to the appellate level to get that, because I see very few cases, and I can't recall any at the lower level court said, okay, this is equity and this is done deal. So it may be that that's their way of keep
the slaves from leaving the plantation.
Yeah, well, keep it under wraps. And so they figure, well, if they come and we'll close the gate on them here, they'll not run around and go through the back gate. They'll just leave, go away.
The way I look at this is it's you either have the wide gate or the narrow gate. The narrow gate is going to get you the success, but it takes the study, the diligence, it takes the knowledge, it takes the higher skill level. Otherwise, everybody just goes through the wide gate and just, but they don't have their rights.
Well, this is an endeavor that takes a lot of time, and I hope the people who are just getting started understand and take that in consideration, that this is not a overnight.
Not a quick fix.
Not a quick fix.
This is a way of life. This is how to be the sovereign king over your estate, over your life. How to operate in the private through a trust, administering a private trust. It's not something that, well, I'm going to fix my immediate problem and I'm going to go back to my stinking vomit that I came from and do the very same thing that got me into the problem to begin with. No. We have a life change.
And that's where it takes that 1,250 to 1,300 hours of studying and listening and learning and studying and re-listening in a lot of cases.
Yeah, we have found out that we have been in the wrong courts all this time. Coming into the at-law side, litigating there, does not get your substantive rights. Only in equity. And they're hiding those courts of equity.
And it seems to me that they're almost like closing the gate and not allowing you to get through that gate to go into that.
Yeah, but then they say, well, no, we really haven't because it's still available to you, but yet it's like the twisty, turny gauntlet path to get into it is so convoluted that in such a high skill level that they figured nobody's going to get in.
Well, that was a comment that the judge made also. He said, you're trying to do something that you need to be a skilled attorney to do.
Ah.
And I thought, well, that's interesting.
Yeah.
Attorney, what you're trying to do. Well, yeah, I don't think there's very many attorneys try to get into equity because, well, they're actually a fiction representing a fiction, I guess.
Right.
And so they're not going to be able to traverse the.
I think we have to know at least an equal amount of what the attorneys know, and whether it's going to be state or federal. Because that's the gauntlet you got to run, and if you get over that hoop, that hurdle, then once you get into equity, you're like on the plateau. Then you're there.
Oh, he also said something that I wanted to run past you and see what you thought about. This was something that he gave me a lecture prior to the hearing starting. He was saying, now, I'm going to answer questions for you, and I'm going to answer them more than I would for an attorney because you're not an attorney. And he said, you are pro se, and as a pro se litigant, you are an officer of the court. And I thought, really? I've been appointed an officer. I thought officers get paid. Where do you think he's coming from whenever he's saying that I'm as a pro se litigant, I'm an officer of the court?
Coming from the at-law side, yeah.
Is that a made-up rule he just decided to make up Monday?
No, I think because all pro ses are operating at law, and all at law is D.C. He's correct. So that determines how he's looking at you. He's looking at you not from an equitable standpoint for some reason. Either there was something that was not equitably pled right, or else he's just saying, I'm not going to recognize your equitable pleading. I'm going to call you pro se and at law, and therefore I'm giving this at law judgment, and this is what I decree.
Well, when I get the judgment, I'll let you know what it says. I was curious to what all he was going to put in that judgment.
So he's going to speak for you as pro se, huh? Are you my attorney, huh?
Well, he was telling me that I could ask questions and he would answer my questions more fully than it would have been if I were an attorney.
Okay. All right.
So I gave him an A+ on that.
What questions did you ask him?
I can't remember. I asked him questions throughout the exchange, but I can't remember any specific questions. It's one of the things I noticed is that he was very skillful at keeping the flow of things in his direction, and I was kind of, like a fellow on a unicycle trying to keep my balance and pedal forward, and I was always trying to catch up.
Uh-huh.
So he kept me kind of directed the way he wanted to go, and I was always kind of behind the curve trying to think about what I wanted to ask as well as answering his questions of what he was asking me.
What hearing was this at?
This was a hearing that we had at the bankruptcy court, and it was a show cause hearing and then a conference hearing to decide where this case was going to go. And because we had filed this equitable pleading to ask the trust to be recognized. So
I wonder if that was an evidentiary hearing.
Well, he put evidence in. He put in the documents and stuff into the case, but they didn't say it was an evidentiary hearing.
Was it your documents he put in, or theirs?
My documents. He put in copies of all of my documents into the case. All the private stuff. As well as the Chapter 7 trustee had filed a response to our equitable pleading and our affidavit report, and then he also responded to our special deposit.
What was the response to the special deposit?
It's illegal. You can't do that. All nonsense. We don't understand it. That was his response, and so he said that it should be dismissed with prejudice.
What was the other party's response?
Are you asking the other parts of his response? He was saying that this bankruptcy was something about the trustee was. Just a minute, let me find my read. I'll read the filing in his complaint to you. See what you think. This is the Chapter 7 response. The heading is the response to notice of merged titles. And it says, comes now the trustee William Clark, Jr., in for his response to the notice of merged titles filed by the debtors, Doyle and Maria, and states and alleges to the court as follows. The trustee does not understand the purpose of the debtor's pleading titled Notice of Merged Titles or their purpose for filing it with the court. It is nonsense, frivolous, and filed in bad faith and without legal justification for the sole apparent purpose of delaying these proceedings. For nearly a year since first filing their voluntary Chapter 13 petition, the debtors have attempted through both this court and the Circuit Court of Washington County, I didn't get to ask him what court or case that was, to twist their bankruptcy proceeding and the resultant bankruptcy estate into some form of an equitable trust. As the court is aware, a bankruptcy estate is not a trust in the sense that trustees receive legal title to the debtor's property while the settlor or beneficiary retains equitable title to such property. Rather, when the debtors file bankruptcy, all of their property, interests, and other rights vested in their bankruptcy estate, and the trustee is charged with administering that estate pursuant to the United States Bankruptcy Code. The debtors recently filed notice of merged titles appears to disregard the many rulings by this court over the last year which addressed the debtors' claims of equitable relief under the trust theory. It also appears to attempt to disregard or otherwise defeat the court's order approving trustees' sale of assets, which was entered June 13, 2011. The trustee requests that this pleading be stricken, or in the alternative, that whatever relief the debtors may be seeking through this pleading be denied with prejudice. Therefore, the trustee, William Clark, prays that the court enter an order striking the notice of merged titles filed by the debtors on July 21st, 2011, or in the alternative, denying any relief to the debtors on the basis of such pleading and for any and all further relief to which he may be entitled.
Now, what was your response to that?
I didn't do a response. I probably should have.
Right, no objection, no.
And nor did I object. I was telling Donnie that I really screwed up. I should have been objecting to everything that he was saying. But I thought this was just a status hearing, and it wasn't a hearing to be putting in, evidence or anything of that sort. Really didn't know exactly what kind of a hearing we were going to be going to. Let me read you what the judge wrote. This is from the judge. This is Richard B. Taylor. This is his notice of status conference in order to appear and show cause. And it says, my name and my wife, debtors, filed their voluntary Chapter 13 petition on August 24, 2010. The Honorable Ben T. Berry, Judge Berry, issued an order to show cause why the above captioned case should not be converted on November 29, 2010, and the case was subsequently converted to a Chapter 7 on December 16, 2010. On June 22, 2011, the debtors filed their affidavit in fact in support of appointment of trustee affidavit in Washington County Circuit Court of Arkansas. The affidavit named Judge Berry the trustee of the debtors' private equitable trust. The debtors simultaneously mailed documents, notice related to appointment of trustee of the private equitable trust, and documents related to a special deposit to Judge Berry. On July 12, 2011, Judge Berry transferred the case to the Honorable Richard D. Taylor. On July 21, 2011, the debtors filed a series of miscellaneous documents. These documents, docket entry 337, do not appear to be pertinent to the debtors' Chapter 7 proceeding. They don't recognize or understand anything that's private. Pursuant to 11 U.S.C. subsection 105, subsection D, the court hereby sets a status conference to assess and consider the current status of the case. Additionally, and pursuant to Federal Rule of Bankruptcy Procedure 7012F, the debtors are hereby ordered to appear and show cause why their miscellaneous documents should not be stricken as redundant, immaterial, or impertinent to the case. The debtors are further ordered to appear and show cause why they should not be compelled to withdraw or dismiss their affidavit, which has caused considerable burden and delay to the adjudication of their bankruptcy case.
Dismiss their affidavit? Is that what you said?
Yeah, dismiss my affidavit.
I don't like that affidavit.
Just to compel to withdraw or dismiss their affidavit, which has caused considerable, and he says it's caused considerable burden to Judge Berry and delay to the adjudication of their bankruptcy case. So whenever we went, we thought we were just going to a status conference and kind of really didn't know how to approach it or what it was going to lead to.
But they're striking all your documents.
Yeah, and what it ended up being was they just threw everything out, denied everything.
Right. So you don't have a case. So it's unopposed, and they can come in and do the rest.
So we may or may not have a leg to stand on as far as filing an appeal to appeal the decision to deny trust.
Well, that you still may have grounds for an appeal. I have to think about what you just read there. That affidavit, they don't like that affidavit.
Now, this was an affidavit, in fact. In fact, I can read that to you if you'd like. Would you like for me to read that to you? What really stirred them up?
Yeah, go ahead.
Find it here. I will read it to you. Now, all it was a notice that I put into the county. Must be in that first part. That's not it. Apparently, affidavits that are put into the county, into the public filing, has a lot of weight or something.
Yeah, notices and affidavits are government, private side.
Well, that would be the... That's not it. Well, we'll get it here in just a second. We're feverishly plowing through documents here. I think it was under Exhibit 1. Okay, here it is. Now, this is what we put into the county as an affidavit of fact in support of appointment of trustee. Comes now my name, immortal living soul, warm-blooded man, who bleeds when cut with all of their unalienable rights claimed in full, waive none, and state the following. It is not our intent to cause any harm to the public or to perform any unlawful acts. Therefore, if there be anything herein that be unlawful, it is void where prohibited by law or otherwise. Number 1, affiant are competent to state the matters set forth herein. Number 2, affiant have knowledge of the facts stated herein. Number 3, all the facts herein are true, correct, complete, admissible as evidence, and if called upon as a witness, affiant will testify to the veracity. Me and my wife, family of Smith, declare that we are over the age of 21 and have reached the age of majority. As donor, settler, grantor, beneficiary, executor, and holder of the power of appointment pursuant to the Holy Bible, the Scriptures, and as reference to the Power of Appointment Act of 1951, Title 26, Sections 2038, 2041, and 2514, we, Doyle Dennis, and my wife, family of Smith, hereby appoint Your Honor, Judge Ben T. Berry as the trustee to the legal estate of the decedent involving the above case number, and as such, you may be liable for all the taxes under Title 2612 related to your claim. We believe you will be liable for all taxes or all taxable termination. You will be liable for the taxable distribution, and you will be liable for the direct and or indirect skip taxes. We also demand that you provide copies of documents which have been filed with the IRS related to the legal estate of the document or decedents, all capital letter name regarding this case. We also demand that it's got copy stepped across there and I can't read it. The following security agreement, deposit agreement, the escrow agreement, 1099 issued for the public debt issue, and 5 completed W-9 included something, and provide information related to the broker who is brokering this account. We further demand pursuant to the whole Scripture, and quote, and I will give unto you the keys of the kingdom of heaven, and whatsoever thou shalt bind on earth shall be bound in heaven, and whatsoever thou shalt loose on earth shall be loosed in heaven. And it's Matthew 16:18, as reflected in 3-601602, Uniform Probate Code. You put a registered bond with the Treasury of the United States to cover the tax liability of this claim and provide us with the receipt. And that was the affidavit. And that's the one that will be rescinded.
Uh-huh.
So
Just all this.
That was filed in June, I believe.
Like they're using equity to strike your documents, but yet they won't use equity to enforce your rights.
Private rights, yeah. And he claimed that we didn't file or we didn't have a claim for which relief could be granted. So he dismissed all of our.
After they got done striking all your documents, yeah.
When did the 12B6 come into play? After the documents were all stricken or before?
Right.
So
Right.
I guess I should have asked him that.
Uh-huh. That's what they do. They strike your documents, and then they got a 12B6. So there should have been at least some objections with grounds to why they can't, and when it goes through unopposed, then the decree stands or the opposition stands, whatever they said, and you waive your rebuttal.
Is there a possibility of correcting that, or?
Yeah, there's a possibility, but, then the equity comes in and says, aids the vigilance, so.
Well, like I said earlier, we made a lot of mistakes. And
Same ignorance of the knowledge of the right to do that and then use that. Ignorance of the right.
We claim that we were ignorant of that right at the time, and now we've been informed, and so we would like to correct that.
Yeah, because we can get your evidence reestablished again, then they can't dismiss it for 12b-6. It seems like they got you because you didn't know what to say and object and grounds to defeat so naturally what they said stands, and they got their order to strike it, and then once they struck it, then you've got no case, you've got no evidence.
So we're going to need to correct that before we consider doing a appeal. And the correction for that would just be to file an objection or a motion to correct or something stating that at the time that this was occurring, we didn't have knowledge to object, and now we have knowledge and we want to object. And
on the appeal, if they were improperly stricken, they were not ruled upon, the evidence was ignored. Do you have any other affidavits in there on the trust?
Well, we put an affidavit of here.
Have an affidavit. That one is an affidavit of trust appointment, right? That's what it said in the beginning. So.
Yeah, that's what it was. It was appointment of trustee, which apparently carries a lot of weight because they certainly were. That judge was wanting me to.
That's a record. It's a record to establish your facts. It's a fact record that establishes your trust. Now, when they get rid of that, 12b-6, failed to state a claim upon which relief can be granted.
You mean by getting rid of the
evidence, the facts to support you have a trust.
Here's what we put in with the equitable claim. This is an affidavit of truth, and it's my name, make the declaration in support of my petition for application for declaratory determination of trust in the case number under the Rule 61 or 60B1.
Was it before or after this hearing that they struck the documents?
This was one of the documents they were striking.
Well, they're striking that one too. Okay.
They just kind of wiped the whole table off, threw everything.
Right. And they were unopposed too, right?
Yeah.
You didn't object?
Like I said, I wasn't really sure of what we were going into as far as a status conference. I thought a status conference was just that,
Yeah, see, this is where I'm talking about we're breaking down on just basic litigation skills because we got another case that's basically the same thing is happening. That they're moving forward with the at-law side stuff, and we're not coming in with anything to rebut it or oppose it or counter it. No counter motions in there. So if you don't, whatever they say then becomes, that's it. And it becomes unopposed then.
Yeah, well,
the result of that is, 12b-6. They just destroyed your whole case without any objections.
Well, should I have just made it a blanket objection to everything they say right at the very beginning, and every time they said something?
Oral, yes, for sure, but then always oral with a follow-up in writing.
Well, like I said, I didn't know what it was that we were going into, and a status conference to me is a conference, not a hearing and a ruling. So I think we were misled. Trial.
Mm-hmm. Well, I would claim ignorance of that, but file something into the case that's going to oppose that and object to those things. And then ask for, say, a rehearing on the 12B6 motion. Like every piece of paper and everything they have to say is you've got to object to. Create a record in opposition. Otherwise, there is no opposition, then it stands as being unopposed. You didn't oppose it.
Well, the only way I see to learn is through the school of hard knocks, and this is one of those hard knocks.
Yeah. So it's like you have to know what to say, when to say it, and what to put in that blocks the at-law side from running its course, and then move your equitable case forward.
So our correction would be then to file a objection to the ruling on the grounds that we didn't have knowledge at the time that this was going on, and so now we want to object and request a hearing to come back and bring back the equitable pleadings and stuff, and object to all of their, especially the other attorneys' motions.
Right.
They may or may not.
Like everything that they say must be opposed by you in writing in some way with NOI-SOI. That way they can't move forward. You block them.
Well, this is definitely a chess game. You need to know the rules.
It is. It's a tennis game, back and forth. Whoever misses the return volley, that's who the point goes against. You got to keep the ball in motion, and you got to get the other side to flub up on the return. Then you win.
Well, I think those guys are going to flub up. I think they're well crafted and they're are well versed in their craft.
No, not necessarily. I mean, nobody today should lose their property through litigation. Because it is so easy to defeat these people. They don't have any equitable claims. And I'm talking from experience. I know for a fact. They're easy to beat. But people wait too long, get too far into something, and they struggle with what they have to know, and they can't implement what they need to, and they get all chewed up. And then they get all frustrated and start blaming the judges, blaming the courts. No, here it was all us all along. If we had known what to say, what to rebut, how to rebut it, when to put this in, you could have won. Just straight litigation. Nobody should go on a foreclosure today without winning their houses, because these people do not have the notes and the mortgages. And you're going to use the equitable discovery rules to prove your fact that they don't, and when you do, they can't win.
What about folks who have already gone through?
That's not even NTT. That's just straight litigation.
What about folks who've already gone through the grinder and have come out on the other side all chopped up, and now they're all healed up? Is there any way that they
that horse and keep on riding? Because if you don't get back on the horse, that's when you're defeated.
Well, what would be the procedure to go and undo what they've done as far as the at-law?
Well, I'm going to go back and I'm going to get everything back that I lost.
Well, then that would mean that you would need to file an equitable claim, claiming that you were probably frauded.
Well, I don't know about fraud, but
a mistaking?
Mistaken, yeah, definitely mistaken. Fraud and mistake, they're about the same, really. It takes a heightened pleading. You're going to have a higher proof along with it. It's like if you know what these people know, it's you're going to give them so much problems that it's almost like you'll win because you know what they know. And that's just on at-law stuff, period. Now, if you could take that skill and put then NTT and equity on top of it, you've got a situation that you are the 900-pound gorilla because you know how to play in both realms. That's our problem. We don't know how to play in both realms yet.
Well, it appears to me that playing in the private realm is probably fairly easy. It's the at-law stuff that you got to dance and avoid the landmines.
Yes, if I never got into a debtor-creditor contract, do you think I would be in court arguing something at law?
You would not be.
Wouldn't be there. I'd be totally off their radar screen.
Yep. In fact, I doubt if you would be in their law.
If you create no evidence of a public nature that they can get you into their public courts, then how can you even be drug in there? If they drag you in there would no records be there to keep you there.
You know, talking about that, let's talk about some of the things that you have. You
want to talk about a resurrection? It's the people must resurrect themselves because there's no evidence in the at-law courts that can hold them. Death is in that court. You got to resurrect yourself from that death. Death couldn't hold Jesus because there were no sin records or titles holding him. Same principle here.
Yeah.
If there are no sin debt titles holding you, the at-law side has no claim on you.
So by merging title and getting all of these debt titles cleaned up and, going back to chopping the tree down and cutting it out at the root, would solve all of these issues.
Yeah, but what about, you'd have to take care of the existing debtor-creditor contracts or the debts that's got the holds on you. Now, whether you do it on an individual basis, like on a case in bankruptcy here, or all in one swoop, it's going to be the same problem, though, probably. We still don't know how to put the evidence forward that there are no records on us, because they're going to cook records up maybe, and we still have to say, well, that's not based on fact. That should be stricken. Motion to strike that. It's an NOI, a false claim. You got to prove it. Well, I did discovery on your copy there, and the copy comes out, you don't have the original. Where's your original record? You ain't got it? There is no record. Davila versus Shalala. When you can't produce a record, none exists.
Well, that's common sense, isn't it? If you can't produce a record, then there is no record.
That's basic evidence law. But that's what you got to do to them. I'd be attacking their evidence. I'd be objecting to their evidence. I'd be striking their evidence. Now, they don't have a claim. Dismiss that claim for failure to state a claim upon which relief can be granted. They have no equitable claims here at all. But that's where we fall down on. We don't know how to rebut the claims, object, make them produce what they say they have. And they end up winning. Winning on paper presumption. So it just is basic government skills, which is, everybody knows that you got to produce the record, but yet we don't know how to force them to produce the record. Well, that's discovery. Discovery is equitable. Through equitable discovery, you can reverse the imputed guilt on you for being a defendant or debtor and reverse it to them, and now the court looks at them with contempt instead of you with contempt as being the debtor or the defendant. But you do that through the discovery, equitable discovery, and a reversal. You convert it on them. And that's just
fallen down.
A straight litigation with an equitable twist. Not even talking about NTT.
Yeah. Well, we're learning from the error of our ways, I'll tell you.
Well, we need more people. Like I said, I had high hopes for some people who were paralegals that they would, but as soon as they, for one reason or another, either they're too statutory or they went back into disappeared land. We've had several people that were high hopes that were paralegals, and they're nowhere. They're gone.
Well,
and then they won't share information, or they want to save it and do commercial with it, commerce with it. The commercial realm is a drug. It's got you addicted. You're hooked on commerce. You think you got to have it. You got to have the money. But the money's all dead.
Nothing
we
there.
will take our brothers for the fact of the money.
Well, I think it takes a mindset, a special mindset to get into this and go through the grinder and come out as sausage and then grab yourself by the bootstraps and jump back up and go at them again, because this is pretty brutal stuff whenever you go into a court.
Yeah, I know. I've been there before. I know what it's like. I know what it's like to lose.
Especially when you're threatened to put you in jail.
But then, if you go back and you study and get prepared more, and you go into it, the fact that you lost it, hey, if you go back in there with the attitude, I'm going to get it back. Like Patrick Hendrick, give me limit or give me death. There's only one way. You're going to have to kill me, or I'm coming back.
He'll be back. The judge, that was one of the things he said, I don't want you to come back here. You stay away from here. I think he was giving me a hint. Stay away.
Now you're putting rocks in their grinders, and then they're not grinding, they're getting all jammed up in their cogs. You're jamming up their wheels of commerce.
Yeah, they were a little testy over it.
Okay, well, it's getting kind of late, so.
Well, it was a pleasure to visit with you. Thanks for the insight. As always, we couldn't do it without you.
Well, all you have to learn how to do is fish for yourself. And that's all I'm trying to teach people how to do, how to fish, not to give you the fish. If I give you the fish, you get fed for one meal, and now you got to ask for another meal. But if I teach you to fish, you can fish for yourself the rest of your life and feed yourself the rest of the life.
Well, I'm getting hungry getting there, though.
Yeah. All right, well, we'll leave it for another time. Rest up, and we'll come back and beat them up again.
Can't give up now.
Anything in closing?
I have nothing.
All right, well, I guess we'll call it a night then. Everybody stay tuned for the Saturday show, the Monday show, and the Tuesday show, 10 p.m. on the non-talk shoe number, and that's 712-432-0075. and the access PIN number is 149939 pound. And that starts at 10 p.m. That's on Saturday, Monday, and Tuesday. And the only live show we got is the talk show number here on Wednesday, which starts at 8. Tune into those audios that we're repeating, especially the Tuesday night one, because that's the repeat of the top 20. Or you can join the NCT group with Skype and Faith Trust and get access to the group and the audios for download. So in closing, the law is nothing without equity, and equity is everything, even without law. And those who perceive what is just and what is unjust only through the eyes of the law never see it as well as those who behold it with the eyes of equity. Law may be looked upon in some manner as the assistance for those who have weak perception of right and wrong, in the same way that the optical glasses that are useful for those who are short-sighted or whose vision organs are deficient. Equity in its true and genuine meaning is the soul and spirit of the law. Positive law is construed, and rational law is made by it. John Bouvier, Institutes of American Law, 1882, Volume 2, Section 3724, Paragraph 4. With that, I bid you adieu and see you next week. Have a great week. Night.